and Operations. Today is Wednesday, February 12th, and I'm calling to order this meeting of the committee in room 120 of the John A. Wilson Building, as well as over the Zoom platform. The time is 9:34 a.m. The first agency on today's agenda is the Contract Appeals Board. The Contract Appeals Board is an administrative tribunal that provides an impartial, expeditious, and knowledgeable forum for hearing and resolving contract disputes, protests, debarments, and suspensions involving the district. The board is vested with exclusive power to review and decide cases involving the district and its contractors. Reviewing contracts is tricky business because of the time, effort, and stakeholders involved. The board serves as a check and balance on agencies with procurement authority to ensure the procurement laws are followed, solicitation and contract terms are honored, and any violations are remedied. Ultimately, the contract and procurement process must be fair for all parties. The board is comprised of 3 administrative judges. Today, we'll hear testimony from Chief Judge Mark Loud about the status of CAB proceedings and the work it conducts. The second agency we'll hear from today is the Office of Human Rights and the Commission on Human Rights, both integral entities in upholding civil liberties in the district. The Office of Human Rights is an important agency, and its primary function is to enforce the D.C. Human Rights Act and other local and federal civil rights laws. This act serves as a cornerstone of our legal framework, rendering discrimination unlawful across 23 protected traits for residents, visitors, and workers in the District of Columbia, encompassing employment, housing, public accommodations, and educational settings. However, acknowledging the imperfections in its implementation, we anticipate valuable insights from public witnesses today on refining both its protective measures and the agency's complaint resolution procedures. The Office of Human Rights is charged with providing a legal process to those who believe they've been discriminated against. It offers a right to sue in D.C. Superior Court and/or an opportunity to seek administrative remedies before the Commission. Upon filing a complaint, the agency conducts an intake interview, attempts mediation, and proceeds with an investigative phase to ascertain facts. Subsequently, the agency's attorneys present their findings to the director, who determines whether probable cause exists for a Human Rights Act violation, potentially leading to formal charges. Following this initial phase, the Commission on Human Rights assumes jurisdiction. An administrative law judge presides over evidentiary hearings, formulating recommended rulings and associated penalties. Ultimately, a panel of commissioners provides an impartial perspective, culminating in a final decision. Despite this seemingly linear process, the complexities inherent in discrimination complaints often prolong litigation, particularly for litigants who represent themselves. Today's hearing aims to delve into the Commission's staffing shortage and other pertinent challenges. We'll be hearing specifically from the Director of the Office of Human Rights, Kenneth Saunders, and Chair of the Human Rights Commission, Motoko Ozawa. I look forward to hearing from both of our government and public witnesses today. We value your input, and we're grateful for all that you do for district residents. Other members in the Zoom, hold on. Just us for now? Okay. Some logistical instructions for today's hearing. In addition to being in person and on Zoom, the hearing is being live broadcast at briannecanedo.com/live. There is also translation available in the Zoom. If you are in the Zoom, please click on the translation option and select your language, whether that is English or Spanish, so that you can hear all of the testimony. Witnesses testifying on behalf of an organization will have 5 minutes to provide oral testimony, and all other witnesses will have 3 minutes. In order to ensure we hear from all members of the public, I ask that all witnesses stick to their allotted time. When it is your turn to testify, I will call your name. You will be promoted to a panel. You do need to accept that invitation, and then you will have access to your camera and your microphone. For technical difficulties, please send a message to the host labeled as Committee on Public Works and Operations, or any panelist labeled committee staff, or email publicworks@dccouncil.gov. Do we want to have our translator make an announcement just in case there's anybody in the Zoom that needs to move over? Herman, do you want to do that? Thank you. Thank you so much. And for the remainder of the meeting, we'll be doing simultaneous translation, but I just wanted to make sure that if anybody had not yet found that button, that they can hear that from you. Okay. Our first panel includes Andres Mesa from Smile, Candy Hernandez from Smile, Jose Ducarte from Smile, Sierra Barnero from Smile, Maria Elena Pacar, Marina Sorto, and Rigoberto Tejada Reyes. Okay. We are actually missing a number of people. Oh, you're here in person. Okay, very good. Okay, great. Can you use the microphone, please? Thank you. Yeah, you can push the button.
Candy is our participant, Candy Hernandez. She's not here in person today, but we uploaded her testimony. It's in Spanish.
So she's submitting written testimony?
Yes, and then Jose is also our Smile participant, and I guess the translator's on Zoom.
Yes, but we can make that work. So
Okay.
we have Jose and who else is
So we have first Andres, and then I think it was Sierra.
Mm-hmm.
Then Candy's not here in person, and then Jose.
Okay.
Mhm.
So, okay. So how do we're going to have Herman translate sequentially? Let me also select a language in here because I didn't do that yet. Okay, so Herman is going to translate sequentially, so just give him time take breaks. Yeah.
Entonces vas a leer el poquito y él va a traducir en inglés, ¿ok? Estás haciendo leyendo un poquito y el Ok, pero primero va Andrés, ¿ok? Should we have Jose go first then with the translator? And then, or are we still going in the order of? Okay, sounds good. So Andres.
Good morning. My name is Andres Mesa, and I'm a bilingual street outreach specialist at Smile. I work with individuals experiencing homelessness, and I've worked intimately with a large influx of migrants we host in the sanctuary city. Individuals emigrate to DC because somewhere along their inner circles, they hear that the city is safe for them to explore services after fleeing displacement. In 1 year alone, I have served hundreds of limited English proficient clients living in shelter, encampments, and transitional housing to further empower them to seek services, and unfortunately, one of the largest barriers I have seen is the unwillingness to serve individuals who do not speak the same language as we do. I began seeing this barrier over a year ago when I would take clients to the DMV. Among the community, the DMV is known to be a place where you are expected to be ridiculed and underserved. When I accompany individuals, I not only witness this maltreatment, but neglect of resources that are city funded. When visiting the DMV, I can expect eyes to be rolled, under the breath noises and comments to be made, accompanied with a blatant need for improved language services. I no longer feel comfortable sending clients alone to the Georgetown DMV location because I can expect a lack of effort to use the language lines and forms to be given in English. I have to be careful about what city resources and housing options I connect people to because of the negative experiences I witness. Enough is enough, and these agencies need to be held accountable to ensure that all DC residents are protected and given equal access to necessary public services. We are asking for compliance with DC law, not special treatment. Complying with the law will assist DC agencies with improving their service delivery to the community positively impacting overwhelmed shelters, day centers, and service providers by removing stagnation and bolstering exit plans. This year, I provided housing navigation to relocate an individual from city-funded housing because the lack of language services threatened the stability of my client's housing. She struggled to understand housing rules because she was never provided intake forms or case management in Spanish, and I have witnessed the same issue during every single intake I have ever been present at, leading to individuals signing forms that they cannot understand. When providing services to individuals in active addiction or in mental health crisis, for example, we have to be very careful about considering the options we can control. When someone faces these challenges, it is much harder to find a resolution when city-funded detox centers, crisis outreach teams, and stabilization wards do not have the willingness to use language access during this very sensitive moment. I have witnessed a higher rate of denial of services for limited English proficient communities who need wraparound services because when we constantly fail them, we burn the bridge of trust. Recently, when unfortunate times resulted in my client being in the ER, I was the only resource called to dissolve the language barrier. This is a hospital, and I am one person, and to be the only individual translating medical direction and advocacy of pain management, I found it to be a little disappointing. I had to ask and request language line services because I knew it would be a disservice for my client to feel alone and unable to communicate with anyone at a facility meant to help him. I cannot do my work successfully without all the wonderful resources we have in the city. But I ask of this council to fight for everyone to have access to these services despite one's difference in language. I also want to give my thanks for this opportunity to advocate for those who may cry out in a different language because we should be obligated to listen and serve these individuals with quality care. Language access enforcement will drastically improve equity and justice for undocumented and Spanish speaking communities and DC residents. We are fighting for an inclusive, equitable, and thriving community in DC. As a service provider who is interacting on a daily basis with entities mentioned above, we as a city are not where we need to be and need OHR to start holding these providers and city-funded entities accountable.
Thank you so much for your testimony. Go ahead. Who wants to go next? Candy.
Hello, my name is Sierra Barnado and I use she, her pronouns. I work with Smile and am the program manager of Rapid Rehousing in the Latinx Street Outreach Program. I have worked with unhoused people in the district for almost 10 years as a street outreach worker and have been heavily involved in city-funded resource navigation and advocacy. When I transitioned from the organization that I was previously with for many years to Smile, alongside of the closing of Casa Ruby, it was evident that hundreds, if not thousands, of Spanish-speaking and undocumented people were no longer being served. I pitched an outreach program to Smile to serve this special population. Between 2 people on our outreach team, we have served close to 400 undocumented and or Spanish-speaking people in such a short period of time. We have assisted over 50 constituents with getting on their own leases, 50 into various housing programs through coordinated entry. This is a vast number, as in my career, I've worked on DHS-funded outreach contracts that have served only 200 unique individuals in one fiscal year with way more staff and way more funding. Sadly, the stories of these courageous people that have crossed mountains and borders to call DC home are representative of the experience of hundreds of Spanish-speaking and undocumented people experiencing homelessness. These are hardworking people that are fighting for basic human rights like getting an ID without having to take 3 trips to the DMV. People who do not speak English are denied their right to services in their own language every day, and it has been this way for as long as I've worked in the system. This happens on the shelter hotline, at city-funded shelters, outreach programs, drop-in centers, housing programs, the DMV, and at Economic Security Administration sites. A large portion of my work over the years has made me the go-to person for knowledge around supporting undocumented people who are experiencing homelessness. This is a special population that we need to plan around strategically, as Spanish is the second most spoken language in DC. Over the years, I've advocated directly with agencies and assisted with cases, made complaints with OHR, and tried my best to educate others about the language access lines and other resources which are available to city-funded grantees and offices. I am here today because every single day, all of the programs mentioned above are in constant violation of the DC Language Access Act. We must do better as a city on a daily basis because people are denied basic access to shelter, resources, and safe spaces every day. OHR can provide oversight to ensure that DHS is properly training staff and recipients of city funding to actually use language access lines to better serve this population. Someone has to start taking accountability. In addition, SMILE supports the efforts of the DC Language Access Coalition to have the council actually enforce the 2024 Language Access Enforcement Amendment, which would require DC government agencies to pay fines if OHR determines they have violated the Language Access Act. Finally, linguistically competent services are not always culturally competent services. City-funded entities have to know that case management and benefit navigation are two wildly different processes for people who are undocumented and those who have a social security card. OMS was founded because of vast numbers of Venezuelan migrants, but since I started almost 10 years ago in the city, there have been hundreds of constituents that I alone have assisted in housing that have gone to service centers for years before they were even assessed because there was no Spanish-speaking staff members. OMS staff consistently provides linguistically appropriate services to their clients, but do not have the support to provide culturally competent services to undocumented clients. This includes navigating the process of obtaining passports and other records which are required to receive an ID in DC. We now have Venezuelan families who have been in DC for over 2 years that are being exited from supportive services with DC IDs, children in DC schools, and that our DC residents are being denied every day in Virginia Williams because of national origin. Separate but equal services between OMS and Virginia Williams means families are left without clear ways to find places to live. If I have been staying in a hotel for over 6 months in limbo on New York Avenue with children born here and in DC schools, why am I not considered a DC resident? My outreach team serves queer and or undocumented people ages 18 to 30, and we constantly try to do warm handoffs with the family system and other organizations. But the warm handoff does not exist when there's no way to measure that at the front lines, staff are actually using the language line at the least. We are just asking for enforceable equal access. In closing, DC is a sanctuary city, and it is time that we realize that strategically planning for this population means that we ensure that DC law is enforced at all shelters, housing programs, the DMV, and anything that is district funded. We need to stop re-traumatizing our Spanish-speaking undocumented constituents and make more of an effort to include them in these spaces and to make sure information about these meetings even that affect them directly is available in Spanish. Thank you.
Thank you very much. And, Jose?
Hola, muy buenos días. Mi nombre es José Dugarte. Llevo 11 meses en DC. Antes de llegar a los Estados, antes de llegar a los Estados Unidos, pasé por la selva y fue una experiencia terrible. Luego me enfrenté a viajar por 7 países y en México sufrimos un accidente donde fallecieron 2 de mis amigos. He tenido que pasar por muchos retos en la vida. Y al llegar a DC estaba decidido a hacer una mejor vida. Trabajé en todas las oportunidades que pude para pagar mi alquiler, pero al final me enfrenté a un momento en el que el empleador se negó a pagarme. Y me vi obligado a buscar opciones de refugio. No, no conocía mis derechos, no sabía a quién acudir. Y cuando encontré el refugio, no duré porque me sentí asustado. Me decían cosas que no entendía porque solo se comunicaban conmigo en inglés y esto frustraba a los trabajadores. Fui a explorar mis opciones y fue entonces cuando conocí a Sierra y a Andrés de Ismael. En mi, en mis experiencias en el DMV, las colectas de alimentos, los servicios sociales, no me veo incluido o querido en estos espacios. Creo que le falta la concientización pública sobre el área lingüística y sobre cómo presentar una denuncia. Está alejando a las personas que hablan inglés. Vivo en una vivienda temporal y me costó entender la gestión de casos porque los documentos solo estaban en inglés. Solo después de incluir a André de Ismail, pude sentir que me entendían. Tener un trabajador social con el que podía hablar en español me permitió mudarme a un lugar donde puedo encontrar estabilidad. Obtener mi identificación, mi seguro médico y empecé a construir un plan para necesitar el sistema de vivienda. Ayer salí de la sala de urgencia y durante mi estancia en el hospital de Georgia, Washington, mm, nunca me ofrecieron servicio de línea lingüística. Me costó explicar el nivel de dolor y mis necesidades. Y al final tuve que llamar a Andrés porque los médicos y la fisioterapeuta solo se comunicaban en inglés. Solo me enteré de mis derechos al acceso lingüístico porque me encontraba en una situación de emergencia y extrema necesidad. Tenemos que aumentar la concientización sobre el recurso y normalicemos el rendimiento de las cuentas de los servicios financieros. Los servicios financiados por la ciudad como medida preventiva para garantizar que la atención de la calidad sea igualmente accesible. Los gestores de caso y el personal remunerado del programa en el que vivo se sienten como extranjeros para mí. Veo que las personas latinas no recibimos servicios, revisiones ni gestión de casos. ¿Por qué me siento molesto por pedir ayuda en español? Hacer que estos servicios rindan cuenta seria, una capa de seguridad para individuos como yo e innumerables otros que solo quieren vivir una vida mejor. El cumplimiento de esta ley habría proporcionado un resultado diferente a la multitud de personas que no hablan inglés, que se enfrentan a circunstancias similares a las mías. No todo el mundo tiene el mismo acceso a la ayuda que reciben con Andrés y Sierra de Ismail, pero todo el mundo puede y debe tener acceso a servicios en su lengua referida. Esto fue todo y gracias.
Thank you. If you wait, though, we can talk a little bit after this panel. You stay. Thank you. Next, we will hear from Mariana Sorto.
Buenos días, Presidenta Brianna Nadeo, miembros del Consejo y ciudadanos de DC. Me llamo Mariana Sorto. Soy educadora, miembro de MSSPA y resido en DC hace 9 años. Estoy aquí para hablar de un tema muy importante, el acceso lingüístico a la comunidad latina. Recuerdo cuando intenté obtener mi licencia de conducir, me encontré con una barrera lingüística que me impidió avanzar. No hablaba inglés con fluidez y no tenía acceso a un intérprete.
Miss Sorto, momentito.
Okay,
Do we need to have her select the language channel?
I need translation.
I'm hearing Miss Sorto, I see.
Okay.
Right. Is there a way, is something wrong with the simultaneous translation?
Yes, I need translation.
No, can we try that?
Mm,
Thank you. Señora Sorto,
¿sí?
necesita tocar traducción
Sí.
en español.
Necesito hacer pausas para traducir.
It's weird that she can hear me, but not you.
Okay, okay.
Sí, señora, es un botón en la pantalla,
Okay. No.
dice translation,
Interpretation,
interpretation, sí. Toca
English,
Spanish,
Spanish,
sí,
¿sí?
sí.
Ya.
Okay, let's try again.
Buenos días, Presidenta Brianna Nadeo, miembros del Consejo y ciudadanas de DC. Me llamo Mariana Sorto. Soy educadora miembro de MSSPA y resido en DC hace 9 años. Estoy aquí para hablar de un tema importante, el acceso lingüístico para la comunidad latina. Recuerdo cuando intenté obtener mi licencia de conducir, me encontré con una barrera lingüística que me impidió avanzar. No hablaba inglés con fluidez y no tenía acceso a un intérprete. Hice llamadas telefónicas para programar una cita y tomar la prueba teórica de manejo, pero las personas con las que hablé no me proporcionaron un intérprete o alguien que pudiera ayudarme en español. Me dejaron en espera durante mucho tiempo y tuve que colgar. Esta experiencia fue extremadamente frustrante y estresante, pero lo que realmente me hizo darme cuenta de la importancia del acceso lingüístico fue cuando tuve que llevar a mi hija de emergencias. Los formularios que teníamos que llenar estaban en inglés, un idioma que no manejo con la misma fluidez que el español. La terminología médica me confundió y temí interpretar algo mal. Afortunadamente, los intérpretes me ayudaron con la traducción, a explicar los síntomas de mi hija y hacer una conversación con los médicos. Experiencias como estas me han hecho darme cuenta de que el acceso lingüístico no es solo una cuestión de conveniencia, sino de justicia y equidad. Todos merecemos un acceso de servicios y recursos en nuestro idioma. Es fundamental para nuestra salud, educación e integración social. Y es por eso que quiero agradecer a los miembros del Consejo por su apoyo y liderazgo en la enmienda de la aplicación del acceso lingüístico. Esto es un paso crucial hacia una ciudad más inclusiva y accesible para todos. Nuestra meta debe ser asegurarnos de que todos puedan prosperar en nuestra comunidad, independientemente de cualquier idioma. Gracias.
Gracias. Rigoberto de Aradez.
Hola, buenos días. Agradezco a Chairperson Brian Nadeo, a los miembros del Consejo, a la comunidad de Washington, D.C., por permitirme testificar hoy. Soy Rigoberta Tejeda Reyes, educadora, miembro de MSCPA, y resido en esta bella ciudad hace 16 años. Estoy aquí para expresar mi apoyo al acceso lingüístico para la comunidad latina, ya que creo firmemente que es fundamental para mi desarrollo personal y profesional, así como para el de los muchos miembros otros. Tener acceso a servicios y recursos en nuestro propio idioma, el español. Mi hijo se enfermó cuando tenía solo 6 meses de edad. Le detectaron problemas de habla y lenguaje debido a una infección en el oído. A medida que crecía, su condición empeoraba. A los 3 años le colocaron tubos en el oído, pero en el hospital me enfrenté a un obstáculo importante, la falta de traductores. Durante mis frecuentes visitas al hospital, tuve que esperar a que un traductor estuviera disponible para explicarme las indicaciones del doctor. Esta experiencia me enseñó la importancia crucial al acceso al lenguaje en la atención médica. Después de que mi hijo se sometió a una cirugía para quitarle las glándulas adenoides, lo derivaron a una terapeuta de habla y lenguaje. Sin embargo, la terapeuta no hablaba español fluidamente, lo que limitó nuestra comunicación. Durante más de 2 años tuve que confiar en traducciones incompletas y explicaciones parciales. Además, creo que es fundamental que el acceso al lenguaje sea proporcionado por personas especializadas que tengan un profundo conocimiento del idioma español y de los términos específicos utilizados en la atención médica y en la legislación. Esto es especialmente importante en el área como la salud y la justicia, donde una mala interpretación o traducción puede tener consecuencias graves. Es imperativo que los intérpretes y traductores sean expertos en el idioma y en la materia específica para garantizar que la información sea transmitida de manera precisa y efectiva. Esta experiencia me ha enseñado que el acceso al lenguaje es fundamental para la atención médica efectiva. Como madre, quiero asegurarme de que mi hijo reciba la mejor atención posible, pero sin el acceso a un lenguaje claro y comprensible, esto es imposible. Es por esto por lo que estoy aquí hoy, para testificar sobre la importancia del acceso al lenguaje en la atención médica. Espero que mi historia pueda ayudar a destacar la necesidad de mejorar el acceso al lenguaje para las comunidades hispanohablantes. Gracias.
Thank you all very much for your testimony. Excuse me. Excuse me, Andres. Did your client file a complaint with OHR after their experience at the Georgetown DMV?
So they did not file one. It just occurred like yesterday.
Oh, my.
Yes.
Okay. Do you think you will?
I think after learning about the processes today and consulting with my boss, I think it would be a good idea to just to empower the individual to show them kind of what would happen in the future if it ever occurred.
I've made several complaints in the past year with Rosa and OHR with different DMVs, and we've had several meetings, but it always seems like I have to continue to talk to like the director of operations at the DMV and continue to complain to Rosa. I think like OHR is doing a great job, but the fines would definitely help people be more accountable across the board.
Great segue. So you talked about an enforcement amendment to the language access law. Can you talk about what an equitable amendment looks like?
For me, when I send someone who's Spanish speaking or anyone who's a district resident to a public service, like getting an ID or to like hospitals and things, I think everything would be very serious. I think like the $2,500 or $2,000 fine, because district funded things need to start taking accountability. We talk about being very resource rich, but it's important. Just like all the people, they have the same kind of narrative. Like these two people were saying I was in the hospital or I wasn't getting equal access to resources. And these are like very grave. I mean, just like this person talked about her son, I had someone who had breast cancer and had to wait like 4 months for a mammogram because they had DC Alliance and not DC like straight Medicaid. So they couldn't get a provider and they were complaining. They kept going to the ER, complaining about chest pains. And that person's no longer with us. So I think like the highest fine would be good every single time.
Appreciate that. Thank you. The language access law only applies to DC government. So it wouldn't actually help us with hospitals, unfortunately. Though maybe that's something else we can look at in the future. You're welcome to respond.
I think like a lot of DHS funded housing programs coincide with this, and like
Sure.
anything that gets DC funded that people have access to, for sure. And it's like all the systems kind of like relate to each other. So yeah. But I think like there has been progress. Like I think OHR this past year was Rosa's very responsive. But I mean, we kept having to do the same meeting like 5 times, and it takes time out of like actual bilingual staff, when we're out in the field and we have like twice the caseload, when we're having to be translators and case managers and like do like 5 different securities. At the shelter that Jose was staying at, this gentleman right here, I'd had people turned away at the door because they couldn't communicate their work schedules. So people who are getting turned away from city-funded shelters because of communication at the front door.
Appreciate that. Okay. Jose, gracias por su testimonio. Thank you. Thank you to this panel for your testimony. Okay. Our next panel includes Ann Kearney, National Domestic Workers Alliance, Larissa Costa dos Santos, National Domestic Workers Alliance, Sophia Balmian Spencer, National Domestic Workers Alliance, Krista Dabler, APA Legal Resource Center, Dania Lofton, Caresen, and Dana Rosales. We'll begin with Ann Kearney.
Hi, can you hear me?
Yes, thank you.
Good morning, council members, staff, and committee members. My name is Ann Kearney. I'm a nanny, and I've been doing this work for over 20 years. I'm also a leader with the DMV chapter of the National Domestic Workers Alliance, NDWA. I grew up in a town of only 400 people, and living in a big city makes me feel like the public policy makers don't hear my voice. Being able to speak today is incredibly meaningful because workers from my industry need to be heard. My first job was working as a nanny while in college, working 3 jobs to put myself through school. This job paid me $8 an hour. I had no contract, and I didn't even know contracts existed. When I became a full-time nanny in 2011, I still didn't have a contract, even though my employers were attorneys, people who understood the importance of contracts. They never provided me one. It wasn't until later on, when I met other nannies, that I learned about my rights. I found out I should be getting overtime pay after 40 hours, but in this industry, so many of us don't even know what standards exist. The passage of the Domestic Workers Employment Rights Amendment Act was a huge victory. However, a law means nothing if workers don't know about it or do not feel safe using it. Domestic work is an isolated profession, and too many workers have to rely on luck or on finding an online group or community to understand their rights, and this should not be the case. That is why OHR must step up. The office should continue to provide mass Know Your Rights presentations to our community, ensuring clear public outreach so that workers know their rights without having to rely on luck. The website doesn't translate to other languages. Improving language accessibility is vital so that every domestic worker, no matter what language they speak, can access protections. We feel unsafe under the new federal administration. Government agencies must do everything possible to ensure workers feel protected when filing claims. Workers will not come forward if they fear retaliation or immigration consequences. I'm an English speaker, I'm from this country, but many domestic workers do not have those privileges. As many of my colleagues in the industry do not speak English as their first language, it's very important to have the website accessible in as many languages as possible. Many face discrimination based on race, immigration status, language barriers, and many are too afraid to speak up. I urge the OHR to do more to make these protections accessible for all domestic workers. Thank you for the opportunity to testify today.
Thank you for your testimony. Larissa Costa dos Santos.
Good morning. Thank you so much for the opportunity to testify today. My name is Larissa Costa dos Santos. I live in Ward 1, and I'm an organizer with National Domestic Workers Alliance, NDWA. Our organization advocates on behalf of 9,000 domestic workers in Washington, D.C. Nannies, house cleaners, domestic home care workers, those who are essential caregiving and cleaning for the city and make all the work possible. Before becoming an organizer, I worked for over 10 years as a domestic worker, including in the neighborhoods of Georgetown and Friendship Heights. During that time, instead of finding good job opportunities, I encountered harassment and unfair working conditions. One employer even told me that labor rights were not for me as a domestic worker. I felt isolated with no human resources department to turn to and no clear place to seek help. Council member, there's remain a deeply rooted misconception that our labor is not considered real labor. even though we perform significant physical and emotional labor every day. Now, as an organizer, I see how critical is education, enforcement, and outreach to ensure domestic workers no longer face these challenges alone. Under the Domestic Workers Employment Rights Amendment Act, the Office of Human Rights plays an important role. I would like to tell two things that OHR has done well. OHR has co-hosted two Know Your Rights workshop with NDWA. As Anne have told us, this is vital because offer legal information to domestic workers in a community setting. These mass presentations should continue. Also, OHR has been receptive to meeting with NDWA and exploring ways to improve access information to workers. I really thanks all staff all in OHR for doing that with us. However, there are areas for improvement. OHR has created a website dedicated to domestic workers' rights. However, the translation feature currently redirects users to an unrelated page, making it not usable for non-English speaker. This is a major barrier for domestic workers who need critical information in language other than English. As the agency tasked with language justice, OHR must lead by example. Recognizing that many workers struggle with dense legal language, and DWA collaborated with OHR with on a concise one-page document summarizing domestic workers' key protection. Although we provided feedback in September, there was significant delay in receiving updates. We recently learned that OHR does plan to publish this one page soon, and have invited us to give feedback again. We urge for this document to be finalized and published in as many languages as possible. And final, many domestic workers fear retaliation or deportation. As we have been speaking here, a couple of folks are undocumented, and OHR should explain this in the website. It explain clearly in the website that that will not have information shared with immigration authorities. This is very important. So to assure domestic workers can fully exercise their rights under the DC Human Rights Act, OHR must fix the website translation feature, promptly publish the one-page document, provide a public commitment to safeguard workers' information. I'm a proud DC resident. Every domestic worker in DC deserves to know their rights. I really hope that no one in this district hear that there is no rights for domestic workers, as I heard in the past. Public education is essential to build trust with domestic workers and make their new legal protections real and enforceable. Thank you so much for your time. I really hope you guys can hear my requests. Thank you.
Thank you so much for your testimony. We'll now hear from Sophia Malamian Spencer.
Good morning, Councilmember Nadeau and staff. Thank you for the opportunity to testify today. My name is Sophia Balemian Spencer, and I am the Employment Policy Counsel at the National Domestic Workers Alliance. NDWA worked for the respect and recognition of over 9,000 house cleaners, nannies, and home care workers who work in DC and do essential caregiving and cleaning that makes all other work possible. In October of 2023, the Domestic Worker Employment Rights Amendment Act went into effect, granting domestic workers the same protections under the DC Human Rights Act as all other employees across the district. Now that the act has passed, we urge the DC Council to ensure that OHR is actively part of its successful implementation. OHR plays an important role in advancing the rights of domestic workers in DC. Under the Domestic Worker Amendment Act, OHR is tasked with enforcing and investigating domestic workers' DC HRA complaints and providing outreach and education materials. We appreciate OHR's proactive collaboration with NDWA, including partnering with us on 2 Know Your Rights workshops. However, more action is needed. We urge the DC Council to ensure OHR strengthens its support for domestic workers by 1, fixing website translation errors that hinder language access, 2, creating clear, easy to read Know Your Rights materials for domestic workers, and 3, committing to protect workers' immigration information to ensure they feel safe when exercising their new rights. So first, OHR must prioritize language access for domestic workers. 71% of domestic workers in the district are immigrants, and OHR's domestic worker page is inaccessible to them. As detailed in my written testimony, the webpage redirects users to unrelated language justice pages, and the translations which do exist in PDF format are not clearly labeled or easy to find, with subheadings in English to make navigation difficult for non-English proficient or limited English proficient users. We have raised this issue multiple times, but OHR has said it's too big of a problem to fix. Yet this is exactly the kind of issue OHR should be leading on. If the website is only accessible in English, it excludes many workers from accessing critical information. As the agency responsible for language access, the DC Council must ensure that OHR makes language access a top priority and set a better example for other agencies. Second, in addition to the language access issues, OHR's domestic worker webpage contains dense, legally technical information that's difficult for workers to understand. For example, words such as private residences instead of homes are used, as well as legal terms such as hostile work environment without defining what this means. To address these issues, in the summer of 2024, NDWA collaborated with OHR to create a one-page document summarizing these rights. We provided feedback to the draft in September 2024, but waited months for an update. This month, we finally met with OHR staff who plan to publish this document and a pamphlet. We hope to see these documents published soon in multiple languages on OHR's website and urge the DC Council to ensure OHR continues disseminating information that is accessible to all users. Finally, OHR must assure workers that their immigration information will be protected when exercising their rights, so they feel safe reporting violations without fear of retaliation or deportation. We have heard from our members the growing fears of retaliation and immigration-related threats under the new presidential administration. Even before this administration, domestic workers have long been afraid to report workplace violations because of retaliation, job loss, and other immigration-related concerns. The intention of the Domestic Worker Amendment Act was designed to limit the collection, retention, and disclosure of workers' immigration status. However, OHR must provide a clear guarantee to workers that their information will remain confidential when they report violations under the DC HRA. Without this assurance, many workers will hesitate to file claims, fearing consequences. We appreciate OHR's willingness to collaborate, but addressing these key issues, especially language accessibility and worker trust, are crucial. It's a major victory that domestic workers are now included in DC's workplace protections. However, these rights mean little if workers do not have access to clear public information. We ask the DC Council to ensure OHR continues to support the advancement of domestic workers' rights in meaningful ways. Thank you for the opportunity to testify today.
Thank you very much for your testimony. Go ahead.
Good morning. All right. Good morning, Councilmember Nadal. My name is Dania Lofton, and I am the Pro Bono Coordinator and Staff Attorney at Carecen. Carecen has been serving the immigrant community for 43 years. Since 1981, Carecen has been facilitating the process of transition for immigrants to an integrated life in their new home and an improved quality of life where all communities thrive in solidarity and dignity. The individuals and families we serve are primarily Spanish speakers and other limited English proficient individuals, making them among the most vulnerable populations in DC. Unfortunately, these language barriers make otherwise valuable and contributing community members susceptible to a lack of services such as healthcare and legal services, educational programs and services, public benefits and makes these individuals more vulnerable to being victims of violent crimes. Carecen's legal department provides pro bono and low bono legal immigration services to assist individuals and families seeking to integrate into the United States, become more secure, stable, and engaged in the community. Carecen's multilingual staff has been able to successfully serve the District of Columbia's community by providing legal services such as assistance with filing N-400 applications for citizenship, working with the Metropolitan Police Department for victims of violent crimes seeking U and T visas, securing work permits, pro se asylum applications, and know your rights presentations for the community, and other legal immigration and housing matters that directly impact their day-to-day lives in Spanish, French, and Haitian Creole. However, DC's community members are not always able to access necessary services in these other languages to ensure that these members are equipped with the knowledge and empowered. As previously mentioned, Carecen has facilitated numerous Know Your Rights presentations in multiple languages to DC schools, community organizations through partnerships, and universities located in DC. Carecen has also been working with a limited English proficient community member who was the victim of a hate crime in the district because of the victim's ethnicity and limited English proficiency. While working in the hospitality industry, the victim was physically and verbally assaulted by a business owner in DC. While this is not an example of a language access barrier with an agency, it parallels other immigrant community members' experiences in the district. This example supports the need for clear communication between government agencies and limited English proficient individuals that will benefit the entire DC community, such as residents feeling comfortable with calling the police to report problems and individuals understanding their rights in all government settings and interactions. Carecen has also been able to provide pro or low bono legal immigration services to other community members, such as another limited English proficient Carecen community member who is a survivor of domestic violence perpetrated by her partner. Due to concerns around her immigration status and her lack of financial means, she felt that she could not safely leave her situation. Carecen staff worked with her to file a report, cooperate with local police, apply for immigration relief via a program for victims of violence, and connect with other local resources. Carecen is now assisting her to secure a work permit for financial stability so that she can be gainfully employed. There are many other examples of community members like her who have few options or limited resources and for whom culturally competent services are critical in ensuring their ongoing stability and well-being. Strengthening language access services for limited English proficient individuals in the District of Columbia positively impacts and will make a difference in the lives of our neighbors, colleagues, classmates, families, and friends in all 8 of DC's wards. The work of Carecen is vital to the well-being of Washington's immigrant community and the city as a whole. We are grateful for the support of the Office of Human Rights and the DC Council, and we commend the district and OHR for working to eliminate the barriers that hinder community access to essential services, programs, and information provided by the DC government. Carecen urges the council to support the language enforcement amendment that will make agencies more accountable for breaking the language access amendment via a fine structure and support it with the technical support required to enforce and monitor in compliance with the law by the Office of Human Rights. Thank you, Council Member, for your support and leadership on the Language Access Enforcement Amendment and the opportunity to testify today.
Thank you very much for your testimony. We'll now hear from Dana Rosales.
Good morning, Chairperson Brianna Dunn, council members, and DC community. I want to start by expressing my gratitude for the opportunity to testify today. My name is Dana Rosales, and I am a proud mother, a member of MSSPA Multicultural Spanish-Speaking Provider Association, and a longtime resident of Washington, D.C., having called this city home for over 20 years. Today, I'm here to speak up for my Latino community about a critical issue that's close to my heart: language access to the District of Columbia. As someone who's lived and worked in this community, I've seen firsthand the challenges that language barriers can create. I firmly believe that ensuring language access is essential to unlocking opportunities and improving the lives of district residents. Time and time again, I've seen how limited language access has held back my parents, friends, and community members. Growing up, I vividly remember my mom's struggles to understand English. Her face was lit up with frustration and helplessness whenever she had to navigate documents, letters, or school forms. Sorry. Letters or school forms. As a kid learning English myself, I wanted to do so much for her, but there was only so much I could do to help her. One experience that still stands out was when my mom had a critical doctor's appointment after being diagnosed with type 2 diabetes. She needed me to miss school that day to translate and fill out forms for her. I could sense her frustration and embarrassment at having to rely on me as a young kid to communicate for her. It wasn't just the language barrier that made her feel excluded. It was the feeling of losing control and autonomy. For me, it was a bittersweet experience. I felt a sense of responsibility to help my mom, but also a pang of guilt for not being able to do more. I wanted to ease her struggles to make things easier for her. But here's the thing. Following the Language Access Act isn't just about helping individuals like my mom. It's about creating more fair and equitable systems for everyone. When District of Columbia agencies provide language access, they're not only helping Spanish-speaking communities, but they're also strengthening trust and ensuring that everyone has equal access to research and services. It's about creating a level playing field where everyone can thrive regardless of the language they speak. It's about, sorry, I urge the council members to support the Language Access Enforcement Amendment. Its approval will be a critical step to ensuring that individuals, regardless of the language they speak, can fully participate in our community and access the services they need. I want to sincerely thank the council members for their support and leadership on this critical issue. Your commitment to language can make a real difference in our lives and help build a stronger, more inclusive community. Thank you.
Thank you. Thanks, everybody, for your testimony. And you mentioned, although you were not the only one, multiple of you mentioned concerns about materials being translated. Can you walk me through? So, I might actually share my screen, although that could be dangerous. I want to have you show me where the materials are supposed to be. Is it the OHR website? I see you can use the translate button. But tell me what the issue is, because I want to better understand it.
Sure.
I
If
can-
possible, can I defer to Sophia?
Sure, of course.
Yeah, I explained it in a little bit more detail in my written testimony, but if you go on the domestic worker page for OHR, they have this translation feature in the right-hand corner that says Spanish that you can click on, but it redirects you to this other unrelated language justice page. But if you're still on the page and you're scrolling down, you'll see that there are links to PDFs of translations of the web page, but it's difficult for non-English speakers to understand how to even get there, that it's even a translation of the web page, and all of the subheadings are still in English. So it's hard for people to understand that those links are for the web page itself.
Oh, okay. I flipped over to Spanish, but perhaps my reading comprehension isn't good enough to show me that that page is not an accurate translation. Okay. That's helpful and very specific, which is exactly what I needed. So thank you.
I did want to mention that I really appreciate how the contracts are in different languages. So thank you for that.
Okay. Larissa also mentioned in testimony that National Domestic Workers Alliance and OHR worked together in September to create a one-pager, but there was a significant delay. And has that been published yet or no?
It has not been published. We are working on giving a second feedback on what they provided us last week. And we hope that this is going to be online soon. But what I mean with the delays is that there is a lot of bureaucracy of like, they need to check with the legal service and they need to check with multiple instances of the office. And this caused a lot of delay, and we would like this to be a little bit more expedited.
Very good. Thank you. Dana, oh, did Dana leave us? Might have gone. Okay. Great. Anyone else wants to add? Okay. Thank you very much to this panel. Appreciate your testimony today. Our next panel includes Laura Brown, First Shift Justice Project, Executive Director, Lillian Mesa, La Clínica del Pueblo Medical Interpreter Manager, Margaret Snow, DC Hunger Solutions, Susan McClanahan, Equal Rights Center, Fair Housing Director, Nicholas Patton, Neighborhood Legal Services Program Supervising Attorney, Housing Unit. Okay, Ms. Brown, you may begin when you're ready.
Good morning, Chairperson Nadeau and members of the committee. Thank you for the opportunity to testify regarding the performance of the Office of Human Rights. My name is Laura Brown, and I'm the Executive Director of First Shift Justice Project, a nonprofit legal organization whose mission is to help low-income parents and caregivers assert their workplace rights to prevent job loss. First Shift Justice Project routinely represents individuals at the Office of Human Rights. Today, I focus my testimony on 3 items: the Fairness in Human Rights Administration Amendment Act of 2023, the Attorney Drafted Charges Pilot Program, and the need to incorporate the Protecting Pregnant Workers Fairness Act into the DC Human Rights Act. Chairperson Nadeau, we are so grateful for your leadership in shepherding the Fairness in Human Rights Administration Act to its passage. This legislation makes our Human Rights Act stronger because of the increased possibility of meaningful enforcement. The passage of this bill was the result of a successful collaboration between advocates, your office, and staff from the Office of Human Rights, which we also greatly appreciate, especially in the current climate in this city. Second, I'd like to comment on the Attorney Drafted Charges program at the Office of Human Rights. First Shift has not submitted feedback directly to OHR yet, but we intend to do so. First Shift attorneys have generally had a positive experience working with intake officers to file charges in accordance with the guidelines of this program. We cannot think of any reason why OHR would not continue to accept charges drafted by attorneys, as it preserves their resources and capacity just as it does ours. Here are a few constructive comments. Number 1, more training is needed to ensure that all intake officers follow the guidelines. In her testimony, my First Shift colleague, Rosalind Herendine, describes an instance where an intake officer prepared charges for one of her clients, rather than accepting her charges and following the attorney drafted charges procedure. This caused both the intake officer and Ms. Herendine a lot of wasted time. Second, the requirements for the information a charge must contain should comply with OHR regulations. The level of specificity in the guidelines is not supported by regulations or statute. Complaints which are facially valid may be unfairly dismissed. The regulations simply require a complaint to be sufficiently precise to identify the parties and describe generally the practice or action complained of. In contrast, the pilot program requires, among other pieces of detailed information, that the charge include the registered agent of the respondent. While this may be a convenience for OHR staff, the failure to include this information is not a legitimate reason to reject a charge that is filed. And finally, an intake interview should not be necessary when an attorney-drafted charge is submitted on behalf of a complainant. This undermines one of the primary purposes of this program, which is to streamline the process. It is the lawyer's ethical duty to zealously represent their client, and there is no role for OHR to play in policing whether the lawyer has added all possible causes of action or accurately stated the facts before a charge is accepted. With a few slight modifications, we are eager for the attorney-drafted charges process to become part of OHR's permanent standard operating procedure. And finally, First Shift Justice Project would like to again recommend that the committee incorporate the Protecting Pregnant Workers Fairness Act into the DC Human Rights Act to strengthen OHR's enforcement abilities on behalf of pregnant workers. Number one, it is practical and will streamline the charge process. Claimants who have pregnancy accommodations claims generally also have claims for pregnancy discrimination. These claims are covered under two different laws, the PPWFA and the HRA, and consequently, a claimant must file two separate charges. This is confusing and leads to duplication of effort. Incorporating the PPWFA into the HRA would mean that a claimant only had to file one charge instead of two. Number two, it makes the enforcement of the PPWFA stronger. The PPWFA does not provide for additional compensatory or punitive damages, whereas the DC Human Rights Act does. Incorporating the Protecting Pregnant Worker Fairness Act into the DC Human Rights Act is necessary in order to keep pace with the federal Protecting Pregnant Workers Fairness Act, which has provided for these additional damages since it became effective in June 2023. Increasing potential damage awards will also help OHR shepherd more cases into settlement during mandatory mediation and decrease their investigative backlog. And lastly, incorporation into the HRA is most likely what was intended by the drafters of the PPWFA. The PPWFA does not contain definitions or a statute of limitations, which are both important elements that you would expect in a standalone law. Incorporating it into the Human Rights Act would fix this problem. Thank you again for the opportunity to testify. I'm happy to answer any questions.
Thank you very much for your testimony. Lillian Mesa, La Clinica del Pueblo.
Good morning, Chairperson Nedo, council members, and council staff. My name is Lilian Mesa, and I am honored to stand before you today as the medical interpreter manager at La Clínica del Pueblo, a federally qualified health center providing culturally and linguistically appropriate medical, mental, and community health services since 1983. Alongside the DC Language Action Coalition, we urge you to support the Language Access Enforcement Amendment Act of 2025. This critical legislation will strengthen the District Language Access Act of 2004 by improving enforcement mechanism, increasing agency accountability, and improving investigation. This will improve accessibility to vital government services for our diverse community of limited English residents in DC. Many of our patients rely on language access services to navigate essential programs such as healthcare, education, and housing. In the case of healthcare access, we constantly hear from our patients that when they call or visit the ESAA offices to apply for or renew their Alliance insurance, they are unable to obtain support in a language they understand. This can result in lapses in coverage or accessing their medications, which have consequences for our patients' health outcomes. Last year, La Clínica conducted an assessment with 77 of our patients who identified language barriers as one of the primary obstacles preventing them from improving their mental health and managing chronic conditions. Since 83% of our patients have limited English proficiency, access to medical interpretation is essential to their care and a key part of La Clínica's model. Our medical interpretation program works to facilitate access to medical interpreters to our patients at secondary care appointments. However, Due to the large demands for our medical interpretation services, we oftentimes depend on the specialist offices to provide quality medical interpreters for patients. When we follow up with these patients, we frequently find that entities covered by the Language Access Act are unable to provide interpreters and instead will cancel our patient's appointment. For example, a 60-year-old woman with Medicaid had her appointment with a neurologist at a district hospital canceled in December due to the lack of an interpreter. The cancellation of this appointment meant that her access to vital care was delayed, which could have consequences for health and her well-being. In other cases, providers would proceed with an appointment and use the limited Spanish they know, which can lead to a patient's misunderstanding of their diagnosis, prescription, or prognosis. The District's Language Access Act of 2004 does not have effective mechanism to prevent these kinds of situations. We respectfully ask for your leadership and full support in bringing the Language Access Enforcement Amendment of 2025 into law. By doing so, you will reaffirm DC's commitment to the health and well-being of all its residents. Thank you for the opportunity to testify before you today.
Thank you very much for your testimony. We'll now hear from Susan McClanahan.
Hi, my name is Susie McClanahan, and I'm the Fair Housing Director at the Equal Rights Center. The ERC is a civil rights organization that identifies and seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in its home community of Greater Washington, D.C. and nationwide. The ERC as a complainant or non-attorney representative for complainants has filed more than 50 fair housing complaints with the Office of Human Rights in the last 3 years. We appreciate the opportunity to testify this morning. The ERC commends OHR on the modest rise in fair housing complaints docketed in recent years. Since fiscal year 2019, OHR has docketed about 70 fair housing complaints annually. However, delays in the complaint process appear to have considerably worsened in the last year, especially during intake and mediation. The 24 inquiries the ERC and our clients filed in fiscal year 2024 took on average about 6 months in intake. Of the 25 charges docketed that year, it took an average of 4 months to schedule mediation, with the longest pending scheduling for more than 8 months now. While some of the delays are due to limited funding and staff, there are steps OHR could take to improve complaint timelines. For instance, on a number of occasions, OHR has not included all parties when sending letters of notification, which notify the parties of a scheduled mediation. If OHR fails to serve any party, the mediation must be rescheduled so the parties can be properly notified. Additionally, OHR frequently fails to follow up once a party requests mediation be rescheduled, meaning that rescheduling can take months. More recently, even once the parties have signed a settlement, it is taking the office several weeks to sign the agreement and issue closure letters. The ERC recognizes that OHR lacks the staff needed to fully address the complaint backlog. We also appreciate that leadership has been responsive when we've raised concerns and they've worked to move forward complaints that have stalled. Nevertheless, the ERC worries about the broader systemic impact of delays and the challenges on complainants who are navigating the process on their own. Immediate actions such as additional training and improved communication could be taken to help address the worsening delays. Given the need for broad scope improvements, the ERC applauds OHR on its attorney drafted charges pilot program. Through the program, attorneys can submit draft charges for their clients, which improves the intake processing timelines because OHR does not need to conduct an intake interview or draft the charge. The ERC has heard positive feedback from attorneys who've submitted draft charges, and we encourage OHR to make this program permanent. The challenges with the complaint process highlight the heavy enforcement burden facing victims of housing discrimination. With fair housing complaints frequently taking 1 to 3 years to reach a resolution, complainants relive the discrimination they've experienced over and over. As such, it is critical that OHR do everything in its power to fight discrimination at a systemic level. Yet OHR does not accept disparate impact claims. Policies and practices that appear neutral may be discriminatory under a disparate impact analysis if they have a disproportionate impact on a group of people protected by the Fair Housing Act or DC Human Rights Act. Disparate impact provides a powerful tool to address systemic discrimination because it makes it possible to identify and challenge more pernicious, difficult to see cases. For example, overly broad criminal record screenings may be discriminatory based on race or national origin, as they disproportionately affect renters of color. OHR must take the necessary steps so that it can accept fair housing complaints based on a disparate impact analysis. Should OHR need additional resources or staff in order to do so, the ERC urges DC Council to address this budgetary gap. Relatedly, OHR did not open any fair housing directors inquiries in fiscal year 2024. Yet blatant source of income discrimination frequently occurs in the district. Discrimination against housing voucher holders is serving as a mechanism of racial segregation and must be stamped out. OHR should launch directors' inquiries to respond to rampant source of income discrimination. Recognizing OHR's limited resources, source of income testing serves as a critical and immediate opportunity to open directors' inquiries. Since 2021, the ERC has conducted source of income testing on an annual basis for OHR. The ERC has provided OHR with the results of all testing under these contracts. We encourage OHR to file directors' inquiries for any testing that shows evidence of potential discrimination. Additionally, OHR could refer such tests to the OAG and collaborate on enforcement efforts. Lastly, while we have raised several concerns about OHR's performance in today's testimony, we also want to stress the critical role OHR plays in enforcing the district's progressive civil rights laws. Any budget cuts would significantly hinder the agency's mission and make it more difficult for DC residents to meaningfully report housing discrimination. Thank you for this opportunity to testify.
Thank you very much for your testimony. We'll now hear from Nicholas Patton.
Morning, and thank you for the opportunity to testify today. My name is Nicholas Patton, and I'm a supervising attorney in the Housing Unit and Neighborhood Legal Services Program of the District of Columbia. NLSP is a nonprofit law firm that has provided free legal information, advice, and representation to low-income DC residents on civil matters for 60 years. As part of that work, NLSP represents clients who are victims of discrimination under the DC Human Rights Act in their administrative cases brought before the Office of Human Rights. I'm here to testify about concerns that have come about through our advocacy on behalf of district residents at OHR. Specifically, since the pandemic, we have noticed a substantial increase in turnaround time with respect to resolution in cases we filed on behalf of our clients. As this council is aware, those experiencing poverty and housing insecurity are more likely than other citizens to suffer from both physical disability and mental illness. There's an ample research that demonstrates the exacerbating effect of protracted litigation on those with mental health disabilities. My team has witnessed these effects firsthand with our clients, some of whom have waited several years for their cases to move forward. Without divulging those clients' full names, I will now go through some of the issues we've encountered specifically. For one of our clients, who I'll call Miss B, her case began when we filed a complaint after a landlord denied her housing application based on a violation of the Fair Criminal Record Screening Act. Ms. B filed her case in January of 2020. The investigation stage of that case began in September of that same year, which was not abnormal at the time given the public health emergency. However, despite the case being about a single allegation with few facts in dispute, Ms. B waited until January of last year, 3 years and 4 months, for a letter of determination concluding the investigation stage. Without getting into specifics, OHR made a determination against Ms. B based on a question of law that we've now challenged. That challenge was filed with OHR in February of last year and is still yet to be ruled on. A second client, Mr. W, filed a charge of discrimination in March of 2019. A private landlord refused to rent to him based on his status as a voucher holder. Mr. W is a chronically homeless, elderly, and disabled resident of the district. Because of the landlord's refusal to rent to him, he remained unhoused for nearly another year. The investigation stage in his matter concluded with a finding of probable cause in support of his discrimination claim in September of 2020. This advanced his case to the conciliation and hearing phase, but after over 4 years of litigation, and largely due to delays in timely rulings, a hearing in his case is yet to be scheduled. He was 65 years old when his claim was filed. He is 71 now and still awaits a resolution, even as his health declines. A third client of ours, Ms. S, filed a source of income discrimination claim in April of 2022. Last action in her case involved a mediation that was held in July of that year. After over 2 years, Ms. S's case remains in the investigation stage as she awaits a probable cause determination on her claim. While we understand that the litigation process can take time, the delays our clients face are not simply a matter of paperwork. Our clients already experience the myriad issues that accompany systemic poverty. The last thing that we want is for our clients to be dissuaded from seeking redress because the path may add stress and uncertainty to their already complicated lives. Furthermore, many of OHR's cases involve important legal questions about access to housing for DC's most vulnerable populations. Timely resolution of these cases is especially important to our clients. Outcomes in OHR housing matters can make the difference between an extended state of homelessness or the security of a smooth transition to a family's new home. Our clients need OHR to process matters in a predictable and efficient manner. It is critical to them that the agency tasked with enforcement of the DC Human Rights Act and other fair housing laws resolves their cases expeditiously, and that discrimination is investigated and punished swiftly and fairly. We're grateful to the Council for the opportunity to testify today, and on behalf of our clients, we encourage the Council to raise these important questions about administrative complaint timelines at the Office of Human Rights. Thank you.
Thank you all so much. Ms. Brown, can you say more about why it's a waste of time for a litigant represented by a lawyer to go through the intake process?
Well, generally, the intake officers are interviewing the clients so that they can gather the facts about the case in order to add the facts to the charge that was filed that might be skeletal. And that's one interview. But generally, if a lawyer has already drafted a charge and submitted it, there have been multiple interviews that have taken place in the office of the lawyer between the lawyer and the client that fills out those facts. And so to subject them to an interview on top of that leads to delay because there's a delay in getting the interview, having it happen, and then having the intake officer review the notes that they've taken. But it's just unnecessary because the lawyer's job is to ethically represent their client and to, gather all the facts before filing the charge.
So what would that look like? Would it be something like a complainant could waive their right to an intake interview if they had representation?
This happens at the EEOC all the time. If
Okay.
you are a lawyer, you're representing your client, you submit the charge for your client, they skip the intake process.
Got it.
If somebody is not represented and is, trying to pursue a claim pro se, then they make an intake appointment and then they get help from the intake officer to draft their charge and finalize their claims.
Okay. And you think this is contributing to the significant delays at that stage of the adjudication process?
Yes.
Appreciate that. Ms. Mesa, with respect to healthcare access, how is the community filling in the gaps for residents experiencing language barriers when seeking medical treatment?
The community is struggling, as I mentioned. They mentioned the language access is one of the main barriers for them to access care and other services that they are entitled. So in some cases where they're not able to find an interpreter, they're taking children. They're taking children out of the school. They are taking people who are not to hospitals who are not trained as medical interpreters, which could really lead to some misinterpretation. Or as we were saying, some doctors are trying to do the right thing with their limited Spanish. It could end badly for the patient. But the community, whenever we call for meetings and in order for them to come and talk about their issues, they're very forward about what they would like to see.
Thank you very much. Ms. McClanahan, is it duplicative for OHR to open a director's inquiry when OAG has in the past brought charges against landlords for housing discrimination?
So OHR and OAG generally have access to different information. I'm not sure if OHR is making OAG aware where they are seeing repeat complaints.
Mhm.
And in those cases where they are, if OAG is not taking enforcement action, then OHR taking and opening a director's inquiry would help to address those issues.
Okay.
Additionally, the ERC's done source of income testing for OHR, and it's under OHR's decision-making what will be done with that testing. OAG is not aware of the testing as far as I'm aware.
Thank you. Mr. Patton, what has OHR's response been generally regarding your clients' long delays?
We have not gotten a lot of specifics about why. I understand why the delays take place in the investigation stage and the mediation stage. We have not been able to get a clear understanding of why in the post-investigation stage or in the hearing stage, what is causing delays on rulings. One thing that I have noticed that I can speak about in one case in particular without getting into too much detail is there seems to be a dispute between OHR in their enforcement division and some of the hearing officers about whether cases can be disposed of based on the law or a summary judgment motion. And litigating that process has delayed a few cases significantly. It's my organization's position that ending a case on the law would abrogate the right to a hearing that is clear in the statute.
Okay. Appreciate that. Do you think your clients will benefit from the new legislation this committee passed last year, the Fairness and Human Rights Act?
Yes. Is there something specific about the law that you want me to address? But overall, yes, we are supportive of it.
No. Thank you. Appreciate it. Thank you very much to this panel. Appreciate your time today. We're going to move to our
Thank
final.
you.
Thank you. We're going to move to our final panel of public witnesses. If you are in the Zoom and wish to testify, but haven't signed up, please raise your hand and we will promote you. This will be the last opportunity today for public witnesses. Same thing, if there's anybody in the room who wishes to testify, please come forward to the witness table now. This panel includes Kathy Henderson, Nancy Leone, Paola Henriquez, Hand in Hand DC organizer, Rebecca Grafton, IUTA, Training and Technical Assistance Specialist, Language Access, Robert Carmona Borjas, Arcadia Foundation, Sylvie Bello, Cameroon American Council founder, and Ms. Henderson, you may begin when you're ready.
Good morning, Ms. Nadeau, members of the committee, ladies and gentlemen. Commissioner Kathy Henderson. I am the immediate past commissioner for 5D06. I filed a complaint with the DC Office of Human Rights regarding my inability. I filed actually 2 complaints. With difficulty accessing the DC Board of Elections and the continuing access to participate in the lawfully mandated Advisory Neighborhood Commission by the public meetings, which were being navigated by Zoom. And unfortunately, the chairperson decided to behave unlawfully and limit my access. I filed a complaint. I filled out the complaint forms, and the DC Office of Human Rights, no one responded. Well, I shouldn't say no one responded. I also followed up with an email to the director. He responded stating, Mr. Saunders responded stating that someone would get back in touch with me. That never happened. So there hasn't been any follow-up, no communication. Efforts to reach the agency, telephonically are very frustrating because the phones are not regularly designate probably an hour or so to continuously call to get someone to answer, and that's unacceptable. This agency is critical to ensure the fairness and, to protect the equal rights of our residents, our visitors, and people doing business in the District of Columbia. And that just isn't happening. We need this agency to work not on some days, but on every day. And I would like to hear from the director how they're going to improve the performance to ensure that my rights are being upheld and everyone else's rights are being upheld. So I will be submitting my comments, my testimony in writing, and I would like for you to state the date that the record closes. And I'm available for any questions. I'm also the coordinator for 5D Court Watch, so this is a potential court matter that our organization is taking a look into.
Thank you very much. We'll hear next from Nancy Leone. The record for this hearing closes on February 26th.
Thank you.
Honorable Councilmember Nadeau, my name is Nancy Leon. I'm the Director of Advocacy at Many Languages, One Voice. I'm here today to express our strong support for strengthening the capacity of the Office of Human Rights and the passage of the 2025 Language Access Amendment. In December of last year, MLove heard from over 45 DC immigrant community members through 3 community meetings where we heard about their priorities. Across all 3 meetings, language access emerged as the most pressing issue, unanimously identified by participants. Every individual had a personal story about how lack of language access in DC has significantly impacted their ability to access critical services and communicate with DC government agencies. The DC Language Access Coalition has been advocating for the Council's support of the 2025 Language Access Amendment for the last 2 years, which proposes essential improvements to the 2004 Language Access Act. And we're thankful to Councilmember Nadeau's commitment to introducing this legislation. And this amendment will enhance compliance measures, ensure greater accountability, and broaden language access protections for DC's diverse community. Support for this amendment also extends beyond community members. I'm also presenting on the record a sign-on letter endorsed by 28 DC-based immigrant serving organizations, all of whom also support this amendment. And the supporters include critical organizations like Amica, Ayuda, the APA, LRC, the Washington Lawyers Committee, La Clinica, among others. And our unified voice highlights the urgent need for this amendment. Furthermore, OHR plays a vital role in investigating and enforcement this law, and they have been invaluable partners and champions of language access and the limited English community in DC, but they will require additional staff and resources to process these complaints efficiently and ensure compliance with the law. So increasing OHR's capacity is fundamental to enabling them to fulfill their mandate and ensure that all residents can fully exercise their rights. So I urge the Council to increase OHR's resources and pass the Language Access Amendment. Thank you so much for your time and your dedication to all DC residents.
Thank you very much for your testimony. Next, we'll hear from Paola Henriquez.
Hello. Okay. Hi, thank you, Chairperson Nadeau and members of the committee for the opportunity to testify today. My name is Paola, and I am the DC organizer for Hand in Hand, the Domestic Employers Network. Hand in Hand is a national network of employers of nannies, house cleaners, home caregivers, and other domestic workers. Our mission is to ensure that employers of domestic workers have all the resources and education they need to make sure their homes are safe, ethical, and legal workplaces. I bring over 5 years of experience as an interpreter and translator to my work at Hand in Hand, and I see many non-English speaking people elevate the needs for better language access services across DC agencies. OHR has a unique ability to distribute these resources pertaining to domestic workers' rights in other languages, but also ensuring that the resources continue to be translated to multiple languages not yet translated in not yet translated in like Tagalog, for example. Not only is it critical that language related to discrimination be translated into the many languages that domestic workers speak, it's also vital that the wording is easy to understand for workers and employers. We know that discrimination is rampant in the domestic worker industry, and many employers and workers are not clear about about what constitutes discrimination in this type of working relationship. Without a robust outreach program that includes accessible language, employers and domestic workers will not know that this policy exists. Does OHR already have an outreach strategy? How many employers and domestic workers does OHR hope to reach in 2025? And how will OHR reach these populations? Hand in hand, would be happy to work with OHR to help support an outreach program that helps to ensure that that employers of domestic workers are clear about their responsibilities under this law. Thank you so much for your time. At Hand in Hand, we are happy to provide any support for implementation needs from OHR, to collaborate with OHR, and to answer any questions as well. Thank you.
Thank you so much. Rebecca Grafton. Everything okay? Okay. Sure. You want to give some testimony? This is the committee on, this is the hearing on human rights and contract appeals? Is that?
Does it fall in the scope of
No.
when you talk about?
Okay. Okay. Very good. Please feel free to proceed with your testimony.
Good morning, Chairperson Nadeau, members of the Committee on Public Works and Operations, and all members of the DC community who are present here today. My name is Rebecca Grafton, and I am part of the Language Access Program team at the organization Ayuda, as well as a DC resident for the past 4 years. Ayuda's Language Access Program is a member of the DC Language Access Coalition, or DCLAC, and is home to DC's Community Legal and Victim Services Interpreter Banks. Our program is funded by the DC government to provide centralized language access services to the various nonprofit organizations that provide civil legal services and services for victims of crime across the district. A year ago, my colleague Jairo Nunez and many other members of DCLAC testified in this same hearing in support of DCLAC's proposed Language Access Enforcement Amendment to the 2004 Language Access Act. I'm here this year to do so again, as the amendment still has not been introduced and it only continues to become more and more necessary. I regularly hear from colleagues, both at Ayuda and other partner organizations, of their limited English proficient DC resident clients seeking public services and being denied language access at covered agencies. Our program periodically receives requests to provide interpreters for clients interacting with DC government covered entities, or to translate documents issued by those entities because they have not done so. Our program cannot fill those requests because they fall outside our funding considerations and because it is those agencies' legal responsibility to provide that service. Our clients and neighbors are facing barriers while just trying to go about their daily essential business. I have been told stories of individuals struggling to obtain driver's licenses, having to take time off work for multiple visits to the DMV due to the denial of interpretation services. I have heard of individuals turned away at the door when trying to access homelessness services because they don't speak English. I have been told of an individual expected to have her child interpret for her when trying to obtain a birth certificate from the Vital Records Office. Stories like these are just a sampling of many experiences that go unreported. DC residents are being denied services that are funded by their own tax dollars because DC agencies fail to comply with the law again and again. The DC Office of Human Rights Language Access Program is diligent in their work investigating language access complaints and prescribing corrective actions to non-compliant agencies. However, they are limited by the lack of incentive for individuals to submit complaints and the lack of incentive for district agencies to improve. Ensuring language access takes effort, as Ayuda well knows. Planning needs to be done, documents and websites translated, and agency staff need to be trained. We know that public servants have many different priorities to juggle. Therefore, we need an enforcement mechanism to push agencies to take that step and get their systems and trainings in place so that language access can be an integrated and smooth process. This is why DCLAC has proposed the Language Access Enforcement Amendment to add a fine structure requiring non-compliant agencies to pay a fine of $2,500, modeled off the successful fine structure of the Ban the Box initiative. This has to be a top priority now, otherwise we continue to fail the 5% of DC residents, over 32,000 people, who are limited English proficient. This denial of critical services, programs, and information to such a significant portion of the DC population makes our community as a whole weaker, less successful, and less resilient. We need you to introduce and pass DCLAC's proposed language access enforcement amendment and back it with funding through budget appropriations. Thank you to OHR, especially the Language Access Program, and the DC Council for your efforts to make sure that our government works for all DC residents.
Thank you very much for your testimony. Let's see. Ms. Grafton, you testified that many people with LEP have unreported experiences. Are community groups encouraging this population to file complaints with the agency?
Yes, a lot of the organizations that we work with do encourage community members to submit complaints and do, offer what assistance they can.
Great.
But unfortunately, there's just not much incentive for people to take the time out of their busy lives, when complaints, don't necessarily lead to actual improvement or don't necessarily, see systemic results.
Fair enough. Thank you. Thank you, everybody, for your testimony. Truly appreciate everyone taking the time today. We are now going to hear from our first government witness, Mark Loud, Chief Administrative Law Judge for the Contract Appeals Board. Morning. Is it still? Yes. Wonderful. What we'll do is have all of you swear the oath before you begin. You could raise your right hand. Do you swear or affirm under penalty of perjury the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Great. When you're ready, you may begin your testimony. Thank you.
Good morning, Madam Chair, committee members, and staff in absentia. My name is Mark D. Loud Sr., and I'm the Chief Administrative Judge of the DC Contract Appeals Board. My board colleagues, the Honorable Monica C. Parchment to my left and the Honorable Nicholas A. Majette to my right, are in attendance with me this morning. We also acknowledge the entire CAB team for its outstanding service to the board and to the district. CAB is a statutorily created independent executive branch agency first established in 1953. The board's mission is to provide an impartial, expeditious, inexpensive, and knowledgeable forum for resolving protests and contract disputes, Quick Payment Act claims, and contractor appeals from final debarment and suspension decisions of the Chief Procurement Officer. By statute, CAB has exclusive jurisdiction over procurement litigation for over 60 district agencies, the vast majority of whom procure through the Office of Contracting and Procurement, and the balance of whom procure outside of OCP, but are under board jurisdiction through the Procurement Practices Reform Act. On January 10, 2025, the committee sent the board a comprehensive set of hearing questions as to which the board's responses with attachments were transmitted on January 24, 2025. The committee's questions and the board's responses capture the story of CAB's solid performance in FY 24-25 to date in three broad categories: closing cases timely and with expertise, performing adjudicatory functions with maximum transparency, and budgeting spending. In my prepared testimony this morning, I'd like to briefly highlight CAB performance in the areas of closing cases timely and with expertise, and performing adjudicatory functions with maximum transparency. In addition, subsequent to my prepared testimony, I will be available to answer questions regarding the board's docket performance, transparency as noted, but also other questions the committee may have regarding our FY 24-25 to date, budgeting, spending, and/or operational matters. In FY 24-25 to date, the board has had solid performance in all three areas. Let me begin with closing cases timely and with expertise. A number of the committee's questions this year address the board's docket performance. The sum and substance of our responses to the committee's questions in this regard are that in FY 24-25 to date, the board has done an outstanding job in docket performance. That is, timely closing cases with expertise, encouraging and facilitating settlements, and preventing backlogs. Indeed, due to docket performance in FY 24, the beginning of FY 25 marked the 10th consecutive year that CAB has not had a case backlog or aged cases on our appeals docket, and the 14th consecutive year that CAB has not had a backlog or aged case on our protest docket that I've been associated with the board. In terms of the specifics in docket performance for FY 24-25 to date, the following table provides a snapshot. In the interest of time, I'm not going to cover all of the columns and all of the rows of the table, but if you would permit me, I will cover FY 24 with the understanding that we match or exceed performance in FY 25, and the committee has the data in front of it to review it at your convenience. So in terms of the metrics that we're looking at, and these metrics all come from the questions that you provided us, the total cases filed in FY 24 were 32. The total number of pages filed in our cases was 49,040. The total cases closed were 30. The total number of protests closed were 21. The percentage of protests closed that were closed in less than 60 business days is 100%. The average number of business days to close a protest was 33. The total number of appeals closed were 9. The percentage of appeals that we closed that were closed in less than 3 years, which is our metric, was 100%. The average time taken to close appeals in FY 24 was about 1 year and 4 months, and the percentage of our closed cases that settled was 57%. In addition to the above quantitative snapshot of board performance at FY 24 and 25, the board continues to excel qualitatively and demonstrate our expertise in resolving cases. Thus, in FY 24-25 to date, 3 board cases that were on appeal to the DC courts were affirmed. No board cases on appeal to the DC courts were reversed in FY 24, FY 25 to date. Indeed, the board has been affirmed in 10 consecutive cases decided by the DC courts dating back to 2017. I would like to repeat that. Indeed, the board has been affirmed in 10 consecutive cases decided by the DC courts dating back to 2017. I'd now like to move on to performing our adjudicatory functions with maximum transparency. As we indicated in last year's performance hearing, Madam Chair, CAB made historic strides in FY 23, uploading over 40,000 searchable PDF case records to the board's public website. The upload encompassed over 1.2 million pages of CAB records from 1953 to roughly 1999 that previously were not available for public review. In FY 24-25 to date, we continue to upload all records in newly filed cases within 3 business days of filing, except, of course, litigation materials that are sealed pursuant to board order, which protect confidential information. For this reporting period, the board uploaded over 49,000 pages of litigation records, as I just mentioned. Also, as it relates to transparency, the board continues to include an online trial and hearing calendar on our website so that the public can learn when we will have proceedings and they are free to attend those proceedings. We also make, as I said, all trials and hearings open to the public. The table below captures FY24 case filings that have been uploaded to the board's public website, along with data showing 5-year trends. The FY24 data in the table below also responds to several of the committee's questions. I won't list the questions out in my testimony, but they are indicated in the printed version of the testimony which the committee has available. As I indicated, for FY24, the board received 1,643 discrete filings. Those filings encompassed over 49,000 pages of material. All of that has been uploaded to the board's website for public viewing, except for the small number that, as I indicated, are sealed. Continued progress in transparency, of course, requires continued maintenance and servicing of the board's key technology assets. In this regard, the board, along with OCTO, has paid careful attention to security upgrades in FY24, FY25 to date, safeguarding our servers from cyber threats with Microsoft Defender and SolarWinds, transitioning from McAfee malware protection to CrowdStrike Falcon, adopting Scalar VPN to secure the board's remote access to our systems and the internet, and utilizing Microsoft Intune to secure our mobile devices. Further, all of the board staff completed district-required cybersecurity training in this reporting period. These ongoing district-wide security measures are coordinated at CAB through our IT team. In summary, this committee's questions and the board's responses tell the story of CAB's performance in the reporting period in the 3 areas of docket performance, transparency, and budgeting and spending. In my prepared testimony, I focus solely on docket performance and and transparency, and our excellent performance in those regards. As noted, however, the board submitted comprehensive written records to all of the committee's questions on January 24, and that includes budgeting, spending questions, IT questions, and of course, operational questions. This concludes my testimony, Madam Chair, and our board looks forward to answering any questions that this committee may have. We respectfully request leave to supplement our responses post-hearing as the circumstances may warrant. I am now available to answer the committee's questions along with my fellow judges, Parchment and Majette. Thank you.
Thank you very much, Judge Loud. Appreciate your testimony. If the number of cases filed at the CAB is a measure of how well we're doing with contracting, is the fact that have only been 8 filed this fiscal year an indicator that that OCP is performing better, in your opinion?
I don't want to read too much into that. OCP, as you probably are aware, has about greater than 2,000 solicitations hit the street every fiscal year. A very small percentage of those come to the board. So if you look at last year, we had 32 total filing. That's probably less than 2%.
Yeah.
So I think that the inference that can be drawn from that is that there are a lot of people that participate in solicitations that are pleased with the result. That's one interpretation. Or perhaps they're not pleased and they do not pursue actions further with the Contract Appeals Board. But I do think it's worth noting that with the volume of solicitations that OCP does, the number of documented filings at our board, and it's been this way for years, is relatively small compared to the number of solicitations that they do. And so you can intimate that perhaps they're doing many things right. And hopefully over the years, through the cases that we have issued, the decisions that we've written, and what we've stated in those decisions, they're looking at and they're using that as opportunities to improve their practices. If that helps to answer your question.
It does. I see what you're saying. 32 is also a relatively small number as a percentage. One other thing that we've been noticing is that we've seen several instances of OCP taking voluntary corrective actions, such as canceling solicitations or awards in response to protests by applicants. Is that something that you all track at all?
Yes, we do.
Okay. And could you provide data on the number of cases in FY '24 and '25 to date that would fall into that category?
So for FY '24, it's 8 of
Mhm.
21 protests that were resolved through corrective action. For FY '25, it's 0 of 6.
Thank you. Do you come across applicants who do not file protests after talking to CAB about the process, or folks who may be worried about maybe worried about retaliation if they do file a protest?
I do not in my capacity.
Anybody else? Okay. In your performance oversight responses, you mentioned completion of the CAB 5-year IT strategic plan. When does the plan begin to set to begin?
The plan has already begun in terms of implementation of aspects of it. So even as the plan itself requires some tweaking to be a final document, there are milestones in it that we've already begun to address. For example, in FY '23, we did the iManage migration, which placed our formerly on-premises servers into the cloud, and that allows the public to interface with our website and do specialized searches. So that's part of what was in the plan, and that's part of what the plan talked about, the board becoming future ready. Remember, the plan had 3 aspects, which I shared with you last year: being future ready, being user-friendly for the end user, and then automating all of our technology processes. So that prong of the iManage would go to being future ready. We've also, and I shared this in my testimony, upgraded a number of security devices, updated security on a number of our devices, including our servers, including our computers, including our mobile phones, and that's part of what is in the plan. With respect to making the experience user-friendly, that's noted in the plan. In FY '25, matter of fact, this week, we're going to be upgrading to Windows 11, which is the latest version of Windows. That would fall under making the user experience better. We also are recent subscribers to Westlaw Precision. Westlaw Precision is about an 18-month-old tool. It's the next generation above Westlaw Edge, and it is a combination of AI partnering with about 250 senior lawyers and editors to create all new search methodologies. The literature that they shared with us is that in their test surveys, it was taking about 10 to 22 hours to complete complex legal research using traditional Westlaw tools, whereas in Westlaw Precision, they've reduced that down to about 10 minutes. And again, it's a next generation level of legal research that allows you to research fact patterns, not just the law, for example. I hope I'm not getting too nerdy now, but fact patterns.
We like
causes of
nerdy in this committee,
actions.
sir.
Well, in a lot of traditional research, you can research the law, but this allows you to research on more models than just the law to try to get to drill down to that precise level of case that you're looking for. And so that's an example of something that's in the plan and that has been implemented already. So it's being implemented. But what I've found, and I think what we found, is that a lot of developments in technology right now, both probably outside of the district government, but certainly inside of the district government, are very fluid and they're happening rapidly. And so we'll finish a draft of the plan, and then 3 months later, there's some new issue that wasn't even in the plan at all. Windows 11 is a good example. I learned about Windows 11 late November, December. We're upgrading this week. If you look at the version of the plan that I had 6 months ago, it's not in there at all. So that's just one example of many examples. So we're trying to pause the plan so that we can do a better job of truly capturing what's happening on the ground. But where we can implement things that are in the plan, we're doing that.
That's great. And what does the collaboration process look like with Octo or any outside vendors?
There's no collaboration process with outside vendors at this point, unless they're brought in by Octo. But there's a robust collaboration process with Octo that involves our IT director having weekly meetings with the CIOs of other agencies, all coordinated through Octo. And at those meetings, they discuss I think Octo's plan is called the DC Tech Plan, and they have a 5-pillar model of what they're trying to accomplish, the way that we have a 3-pillar model. And there's just robust exchange about making sure that items that they're prioritizing are taken consideration of in our plan, security being a big one. So when you heard me talk about CrowdStrike earlier, or replacing McAfee with the newer security, all of those are driven by Octo.
That's great. Is the estimated cost you gave at the last performance oversight hearing of $31,000, $31,500 for an annual maintenance fee still accurate, or has that gone up?
Yes, that figure pertains to the iManage software tool that we use. The figure is still accurate. We are now in the 2nd year of that tool, and we think that over time that figure may decrease. Part of that figure covers the annual subscription. Another separate part of it covers consulting hours during the course of the fiscal year in case something breaks down or in case we can't figure out how to work through a particular problem that we're having. And so what we found in the 1st year is that we drew down a small number of consulting hours, but you might expect that because it's brand new. In the out years, that may increase. And if it doesn't increase, if over, say, a 5-year trajectory, we're still drawing, or 3 years even, we're still drawing down minimal number of hours per year for consulting, then that $31,000 figure will drop.
That's great. Thank you. Your responses included a monthly reporting requirement called OCP Account Review Team Reports. So your ART P card.
Correct.
What's the purpose of this report and what is the board's involvement in the process?
Well, the ART reports are a requirement of OCP to participate in the P card program.
Got it.
In order to participate, you have to have your monthly ART meetings, and then you have to submit your reports to OCP by the 10th of the following month. And there are opportunities for the agency head, the P card holder in the agency, our OCFO liaison to sit down and go over all of the payment net reports that are generated from that month's worth of procurement activities and make sure that they're reconciled. Make sure, for example, that we didn't accidentally pay sales taxes. You look for things like that. And everyone signs off that they've looked at all of the invoices, they've looked at the payments, they've looked at the detailed activity reports produced by Payment Net. And as I said, if you find something, you have the opportunity to correct it in real time. If you don't, you send it on to OCP. And if you are current all 12 months, you are renewed to use the P card the following year. 14 years that I've been here, we've never had our P card suspended.
That's great. Very good. For the public, can you please describe the board's efforts to increase access to small businesses and pro se litigants who need to raise a claim before the board?
For 4 things. First, we do have a pro bono notice on our website directing parties, including a link to the DC Bar's pro bono program for small businesses. This is a very specialized area of law, and I think one of the best ways small businesses and pro bono and pro se businesses can navigate our system is to work with lawyers that are knowledgeable in government contracts law. So the first thing that we do is make sure that they try to get a lawyer to participate in our process, and we do that by linking to the DC Bar's pro bono program. Secondly, we allow manual filings at the board, even though we're 100% digital at this point, and we have been for a number of years. We will accept manual filings, we will accept walk-in filings, we will accept filings through the mail, so that pro se litigants who might not be connected yet to the technology can still prosecute their claim through our body. Thirdly, we've had discussions and will continue to have discussions with File and Serve about their pro se cost subscription plans. They have a number of customized plans that they will develop. They don't currently have, that we've been able to find out, they don't currently have any pro se subscription plans. We asked about, for example, File and Serve has 1,300 courts that are clients, right? So we asked them about, well, what about domestic relations? Do you have any reduced fees or pro se fee program for domestic relation cases? They said that they don't. We asked them for indigent persons. Do you have any programs like landlord tenant, for example? They don't have any programs for anything like that. But again, they will sit down with the courts and develop customized plans, all for a cost. And so we're having those discussions with them around what that might look like for the board. We don't have a lot of pro se cases. I think we had 4 last year, something like that, of the 32. But again, it's worth looking at. And of course, where we can do more, we should do more, and we're open to doing more.
Very good. I'm pleased to see that the board has sustained its 100% compliance rate for closing appeal cases no later than 3 years after the initial filing date, and in fact sooner at 1.3 years. I'm curious what you're doing to sustain this accomplishment.
I'm going to ask my board colleagues to feel free to jump in too, but let me start off by saying, so when I first started this job, I did a first 100 days report on what I found at the agency. And in that report, there was a strong, we inherited a huge backlog. Judge Parchment and I, Judge Majette joined us several years later, but we inherited a huge backlog, and probably half the docket was backlogged. We came 2010, I think I came a few months before, 2010, 2011, and we had cases at that time that went back to Y2K. We literally had cases where the contract had been awarded to prepare the agency for Y2K. And this was 2010, those cases were still open. So in doing that 100-day report, what we found was that during periods where there were board vacancies, the docket skyrocketed. So there was a period from 2005 to 2010 where instead of having 3 judges, the board had 2. So now I'm going to answer your question. So I draw a correlation between our ability to continue to hit the 100% target that we're hitting, because there haven't been any board vacancies in 14 years. So I think there's a correlation between having board positions filled and being able to excel at the docket. That's number one. Number two, around 2013, I think, at the suggestion of Judge Parchment, who's sitting to my left, as part of the senior team meetings we were having then, I think it was 2013, we had tried a pilot program of internship attorneys for a while and volunteer attorneys through law school, and it was helping us make a dent. But Judge Parchment suggested, well, why don't we just look at having FTE attorneys on staff? And so we explored that. We did the homework. We did the research. We came back to the council and we presented a proposal to have attorney staff that help the judges manage the docket, do legal research, do some of the front end work that law clerks do in traditional courts. So in the time that we've had that up and running, we haven't had any significant vacancies in the attorney positions. So I think that that's a factor. So having no vacancies at all in the board judge position, having no vacancies and no significant vacancies in the attorney positions are all things that help us continue to hit that 100% rate. And then I think being very aggressive in how we manage each case. So appeals that come to our board have to have a trial date within 2 years of the initial date of the filing, and that's in the initial scheduling order that we all issue in the cases that we are presiding judge in, and we manage the case from that vantage point. In other words, you've got to go through discovery, your motions practice, your depositions, your expert reports. You do all of that with a view toward making that trial date, which is going to be no later than 2 years. Where we can make the trial date earlier, we will do that. But from the beginning of the filing, the game clock, to use a sports metaphor, the game clock is ticking, and you know that you are going to see a trial. That was one of the issues, I think, that when Judge Parchman and I first came, was that you had cases that were going around and around and around and around. There was no certainty that at some point, this case is going to be tried. Well, now there's an absolute certainty that when you come here, there's going to be a trial. If you're the government and you lose, you could be losing millions of dollars and paying the interest that's required under the statute. If you're a private party and you don't have a viable claim, you could be losing hundreds of thousands of dollars in attorney's fees. But there's an expectation, I think, from the ecosystem that when you come to CAB, you're going to have a trial, prepare, review your case, understand the strengths and the weaknesses, be positioned to have settlement discussions if you think that that's important. But I think the four things that I've mentioned, the lack of board vacancies, lack of attorney vacancies, rigorous scheduling, are all things that help us to stick to that 100% closure. We have, I mean, obviously it goes without saying, we have a great team doing all of that, but that's sort of the framework that the team fits into.
Thank you. How often do you complete cases prior to the 3-year mark, for instance, within 3 months, 6 months, or a year?
Well, you saw in our answer to question 44 that we're doing last year anyway. But I believe it's this year. Yeah, this year, FY25. This is in answer to question 44. We're closing appeals in 292 days, which is less than a year. Last year, we closed appeals in 483 days, which is about a little over a year.
Could you say that again?
I'm sorry. In FY24, and this is in our answers to your question 44.
Right.
We closed appeals at an average rate of 483 days in FY24, which is a little over a year. This fiscal year 25, we're closing appeals at a rate of 292 days, which is less than a year. In my personal experience, I don't recall a lot of cases settling in 3 months or being disposed of in 3 months through written decision. I think it's possible when the parties realize early that they want to settle and they start immediately down that path. I would find it difficult to think that there's a way we could litigate a case and close it in 3 months when you have discovery and all of those kinds of things. I would say the same for 6 months. If the parties are genuinely committed to settling, I think that cases can close in 6 months. I don't know if they can be disposed of through trial, but perhaps through motions practice, summary judgment, motion to dismiss, that might happen. I think it's a little more common when you move out to a year and 2 years that you're going to get cases that are resolved in less than 3 years. In fact, I think when we came before you last year, I didn't do it this year, most of the cases that closed were less than 2 years. Yeah, so we have that 3-year metric because the National Center for State Courts says that 3 years is the appropriate metric for complex civil cases, and our government contracts appeals cases would fall into that category because of the presence of experts and depositions and robust discovery. But there are many, many, many occasions where, as our answers to your questions indicate, it's not taking 3 years. There's some where it does take 3 years.
Thank you. In your responses, you mentioned the board estimates needing $18,000 to meet the DC Archive's updated records indexing requirements. Could you share some additional detail on that?
Sure. So you will recall in my testimony me saying that in FY23, we uploaded over 40,000 PDFs to our website, 1.2 million pages. Those PDFs are in roughly 600 boxes in our office. And in order to archive those records, those 40,000 documents, Archives requires, Federal Records Center requires that on the outside of each box, there is every document in the box is identified. So there's a docket list on the outside of the box that has to be identified for every box. That's probably, just in terms of the labor involved, that's probably the biggest part or big chunk of that $18,000. But the boxes are also palletized. You use shrink wrap, try to say that fast, shrink wrap for all 600 boxes to deliver them to the Federal Records Center. You also have to get what the Federal Records Center calls accession numbers, where they go through their own process of identifying what's in series of boxes. So we have to identify what's in each box, all 40,000 documents. Then when it goes to Federal Records Center, they identify what's in a series of boxes through these accession transmittal forms, and an accession sheet will identify what's in a block of 50 boxes. That process takes, it's very labor intensive, in other words, is what I'm describing. So $18,000 may sound like a lot of money, but when you take a step back and think about the level of work that's involved and the precision, you have to be correct. You have to be good about identifying what's in the boxes, because when future years researchers come, they'll rely on your accession numbers, they'll rely on your docket entries to actually retrieve the specific document. So it is a process that takes a while.
Do you anticipate needing this funding in the upcoming budget year?
Not in FY26. Once we shake out a little bit better some of the technology costs, and in fact, our team is meeting later this month to go through our IT plan and vet it much more, we will have a better idea of whether FY27 would be good for that or FY28. Because again, we don't want to, these boxes are in a storage area in our office. They're secure. There are no immediate danger or threat of anything. And so we don't want to commit a block of money to those if we're going to have an emergent issue in technology that's more important. That's what happened with iManage a few years ago. iManage was a program that for us was running fairly well, but we had the servers on premises, and the vendor announced that they would not do business anymore with any of their clients that had premises, that had servers on premises. All of their servers had to be in the cloud. Mm-hmm. So for example, if we had sought $18,000 in that particular year, it would not have been a good buy for us, because we had to get to in-cloud servers for our iManage program. And apps in the future, so I'm told, I'm not the most tech ingratiated person, but apps in the future are being built to function on cloud servers only. So if you have an on-premises server, they're not going to be strong enough. So that's something that we had to do. So I'm saying we're allowing room for things like that might happen, and we won't know that until we really vet through this IT plan. That might be more important than spending $18,000 on delivering these boxes to the Federal Records Center. If nothing like that surfaces, that is the plan, though, to get them out of our office as soon as we possibly can.
Are they physically in your office?
They're physically in our office.
600 boxes?
600 boxes. We have a large storage area that has, it's a multi-purpose room. It has copiers and other equipment, office supplies, and these boxes.
And 600 boxes.
Huh?
And 600 boxes.
And 600 boxes.
Okay. Oof. Well, thank you for that explanation. And those are all the questions that I have for you all. I want to thank you each for your testimony and your service. We appreciate you taking the time to come in and be with us today.
Thank you. We appreciate you, and we appreciate your team for all the support you give us.
Very good. We're now going to be turning to the Commission on Human Rights and the Office of Human Rights. We'll be joined by Mr. Kenneth Saunders, Director of the Office of Human Rights, and Commission Chair Azawa And just like the other panel, when you're ready, I'll swear you in. Anybody who could be giving testimony should come up now and be sworn in. Hey, if you would all raise your right hands, please. Do you swear or affirm under penalty of perjury the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Thank you all. I appreciate everybody doing it at once, just in case. Okay, you may begin your testimony.
Good morning, Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations. I am Kenneth Saunders, Director of the District of Columbia's Office of Human Rights. Thank you for inviting me to discuss the activities and accomplishments of OHR in fiscal year 24 and fiscal year 25 to date. OHR achieved remarkable progress in fiscal year 24, strengthening its commitment to protecting human rights and fostering inclusion across Washington, D.C. Through diversified outreach, enforcement, and enhanced operational efficiency, OHR made strides in expanding its impact citywide. Key highlights of FY24, including implementing newly enacted legislation, developing new enforcement strategies aimed at improving access to OHR services for marginalized communities, achieving the agency's recruitment goals, and celebrating significant milestones such as the 20th anniversary of the DC Language Access Act. I will provide a synopsis of FY24's major accomplishments and my vision for this fiscal year. I will again begin by providing an overview of OHR's work. OHR is the District of Columbia's quasi-judicial agency tasked with eradicating discrimination, increasing equal opportunity, and safeguarding human rights. Through the enforcement of local and federal civil rights laws, OHR serves as a crucial resource for residents, visitors, and employees seeking justice and fairness in employment, housing, education, public accommodations, and government services. By providing a cost-free legal process for complainants, OHR ensures that individuals have access to justice regardless of their socioeconomic status. OHR employs a comprehensive approach to its enforcement, combining enforcement with proactive measures such as public education, outreach, and training. OHR's enforcement process begins with the filing of a complaint alleging a violation of one of many laws OHR enforces. On the docketing of a complaint, the parties participate in mediation. And if a settlement of allegations is not possible, OHR conducts an investigation of the allegations and issues a determination on probable cause. If probable cause is found, the case is certified for an evidentiary hearing, which both parties can present evidence and testimony before an administrative law judge or hearing examiner. OHR attorneys prosecute private sector cases alongside complainants in pursuit of the public interest, which is a unique feature that underscores the agency's dedication to public interest and accountability. These protections often result in OHR entering into voluntary compliance agreements with respondents to address the public interest relief. The DC Human Rights Act authorizing statute protects 23 traits across its enforcement areas, making it one of the nation's most comprehensive civil rights statutes. The act was recently amended to include broader definitions of harassment, then coverage to independent contractors and domestic workers. and all additional protected traits, including homeless status and sealed eviction records. Federal laws, including Title VII of the Civil Rights Act and the American Disabilities Act and the Fair Housing Act, complement these local protections, enabling OHR to provide a robust framework for addressing discrimination. Over the years, the district has established itself as a leader in civil rights, and OHR's portfolio reflects this commitment. In addition to enforcing the DC Human Rights Act, OHR is now responsible for enforcing several new anti-discrimination and compliance laws in FY '24 and '25. These include the Sexual Harassment Data Collection Act, Domestic Workers Employment Rights Amendment Act, the Human Rights Enhancement Amendment Act, the Eviction Record Sealing and Fairness in Renting Act, and the Open Movie Captioning Act. In addition, the Council and the Mayor just approved new amendments to DC Human Rights Act, the Fairness in Human Rights Administration Act, which is not yet in effect, but will change OHR's procedural operations in the near future. OHR also enforces several other local laws, including DC Family and Medical Leave Act, DC Parental Leave Act, parts of the Universal Paid Leave Amendment Act, the Unemployed Anti-Discrimination Act, the Protecting Pregnant Workers Fairness Act, the Fair Criminal Record Screening Amendment Act, also known as Ban the Box, the Fair Criminal Record Screening for Housing Act, the Tip Wage Workers Fairness Act, the Racial Equity Achieves Results Act, the Care for LGBTQ Seniors and Seniors with HIV Amendments Act, the Youth Bullying Prevention Act, and the DC Language Access Act. OHR achieved significant milestones in FY '24, strengthening its operational capacity and expanding its reach in the community. FY '24, OHR welcomed 10 new full-time employees, including key positions such as the Director, Attorney Advisor, Alternative Dispute Resolution Mediator, and Equal Opportunity Specialist. These new hires strengthen OHR's capacity to deliver on its mission by ensuring the agency is equipped to handle the expanding responsibility and meet the needs of the district residents. OHR continues to make recruitment and retention a top priority in FY '25. OHR filled 6 vacancies in FY '25 to date. OHR expects to maintain this hiring trend through the end of the fiscal year and is on track to fill all of its vacant positions. Similar to nationwide trends, OHR has experienced hiring challenges due to the changes in the job market stemming from the COVID-19 pandemic. Additional challenges, such as difficulty competing with market compensation and hard-to-fill positions, present additional recruitment challenges. In FY '24, OHR redeveloped its recruitment and retention strategies to focus more on total rewards. The agency increased recruitment efforts by expanding its recruitment networks to attract more diverse and qualified applicants and participating in more district-wide career fairs. To address retention challenges, we developed more attainable career ladders and growth opportunities within the agency and made more incentive awards available to employees. In doing so, the agency successfully met the district's goal of attracting, developing, and retaining a well-qualified, diverse workforce. OHR will continue with these efforts in FY '25. Community engagement remained a cornerstone of OHR's work in FY '24, and the agency is expanding its outreach efforts in FY '25 to better engage underserved and underrepresented communities through targeted strategies and new partnerships. The agency conducted 67 outreach and training sessions, directly engaging more than 3,000 residents and reaching almost 7,000 individuals. Collaborations with local organizations such as civic associations, advisory neighborhood commissions will help introduced resources detailing the civil rights protections available to the residents this fiscal year. In FY24, OHR partnered with local LGBTQIA+ community-based organizations to empower, protect, and raise awareness of their protected rights under the DC Human Rights Act, especially as the district prepares to host World Pride 2025. OHR has continued its outreach efforts to community organizations and advocates who represent parties before the office, including through scheduling of quarterly CBO meetings and public outreach events. In early FY25, OHR's Office of General Counsel participated in an online webinar held by the Metropolitan Washington Employment Lawyers Association that brought together OHR, the Office of the Attorney General, CBOs, and even judicial participants to discuss OHR's complaint and adjudication processes and practical tips for litigating claims brought under the DC Human Rights Act, both before the Office of Human Rights and in Superior Court. The OGC was also invited to present at the annual Practicing Law Institute's Municipal Law Conference to provide updates on civil rights enforcement laws in the district. The agency will continue its quarterly lunch and learn sessions to help staff gain a deeper understanding of racial equity issues and provide actionable insights on how to incorporate racial equity into its daily work practices. OHR has joined the DC Office of Racial Equity in the 3rd Racial Equity Action Plan cohort. By participating in the Racial Equity cohort, OHR has made strides in developing a comprehensive racial equity action plan for the district government that guides our internal processes and ensures equity is embedded in our service delivery. OHR's Creating Safer Spaces unit provides education, raises awareness through outreach, interventions, and enforces compliance through 2 main efforts: sexual harassment prevention training and policy submission for tip wage industry, and new rights and legal protections for LGBTQ seniors and seniors with HIV in long-term care facilities training. Team increased the number of train-the-trainer sessions and the number of certified trainers and the number of staff receiving trainings in these areas. OHR has certified 315 trainers since its beginning, 130 of them during FY24. Since the program's initiation, more than 700 tip wage businesses have engaged in sexual harassment prevention training activities. This is the 2nd year of the Care for Seniors program, and the program experienced significant growth over its initial goal of 25 new trainers by certifying 52 new trainers in FY24. The staff participated in 14 community events and online meetings to increase visibility, program awareness. These engagement activities have fostered meaningful collaborations, strengthened ties within the long-term care community, and promoted awareness of the law and its impact on LGBTQ seniors and seniors with HIV. In FY24, the Language Access Program continued to enhance accessibility for limited English proficient and non-English proficient residents. The LAP hosted the Language Access Stakeholders Forum in FY24. This event brought together community members, advocates, and government representatives to review and plan language access achievements and address challenges. Over 20 agencies, including language access coordinators and agency directors, participated alongside representatives from approximately 20 CBOs and service providers, including LEP and NEP community members, totaling over 200 attendees. Last year also marked the 20th anniversary of the DC Language Access Act, with over 200 stakeholders attending the event. In FY24, the Language Access Program introduced a new compliance measure requiring agencies with automated phone systems to develop multilingual phone trees. Language Access Program is currently assessing the implementation of these measures. Covered entities with significant public contact will be evaluated based on 15 language access compliance measures, provided they undergo field testing. OHR's Youth Bullying Prevention Program will continue to amplify its Youth Human Rights Ambassador Program in FY25, urging students to engage in human rights education and advocacy, collaborating with schools across the district and building new partnerships with parents and educators. The program will strategically be promoted alongside with the Youth Bullying Prevention Program to connect with more students and their families. In FY24 and continuing in FY25, OHR established a comprehensive 8-week training for current and new investigators. This initiative will continue to increase productivity and improve the work quality, allowing more civil rights cases to be adequately processed for the district's residents, visitors, and employees. In FY25, OHR also onboarded a new Associate Director of Enforcement who comes from a neighboring civil rights enforcement agency with a record of experience and knowledge managing investigative teams. As part of the Associate Director's new duties, OHR has begun developing a new internal processes for intakes and in finalizing internal guidance for the use of fact-finding conferences as one of OHR's authorized investigative tools in certain cases. In addition, OHR is currently in the process of recruiting an intake supervisor who will lead a separate unit dedicated to conducting intakes. The goal of this unit is to decrease the time that individuals must wait for an intake appointment. Furthermore, this dedicated unit will enable the investigators to focus on conducting investigations, which will assist in reducing the office's inventory of aged cases. OHR's enforcement work in FY24 was marked by efficiency and impactful outcomes. The agency received more than 1,300 complaints and docketed over 300 charges of discrimination. Through its mandatory mediation program, OHR conducted almost 300 mediations and secured almost $500,000 in recovery for complainants. OHR has set an ambitious productivity goals for the enforcement unit with a focus issuing determinations of letters of determination. In FY24, OHR issued 160 LODs with 64 findings of probable cause. In FY25, OGC has continued pace and has already issued 33 LODs in FY25 to date. Public interest litigation has also played a critical role in OHR's work advancing systemic change across the district. OHR attorneys have participated in the litigation of over 20 probable cause cases before the Commission on Human Rights in FY24 and FY25, achieving notable victories such as securing voluntary compliance agreements with 6 respondents over the past year, completing monitoring period with an additional 13 respondents. These agreements required multi-year monitoring, mandatory training, posting of OHR notices and posters, and policy updates to align with the laws that OHR enforces. OHR has already entered into 2 VCAs in FY25 and is to make the VCA process more understandable and accessible for respondents who litigate before the Commission on Human Rights, including the creation of a public fact sheet on OHR's relevant authorities and processes for obtaining respondents' voluntary compliance with the law. OHR recently received a performance assessment review from the Department of Housing and Urban Development. In the review, OHR was praised in several categories, including its timely initiation of investigations and the comprehensive documentation contained in its final investigative reports. its mandatory mediation program and successful compliance mentoring of agreements, its fair housing community education and outreach trainings, exceeding its case processing goals, reporting of cause cases, and adhering to terms of the Memorandum of Understanding. Overall, OHR met or partially met 8 of the 9 performance standards reviewed by HUD. In FY23 and 24, OHR partnered with the Equal Rights Center to conduct fair housing testing for compliance with DC source of income protections. In FY23, 158 tests were conducted across 149 properties, revealing potentially discriminatory practices in 73 cases. FY24's testing focused on reevaluating these properties. OHR is currently analyzing the preliminary results to determine enforcement actions. Another achievement in FY24, which was continued in FY25, is OHR's revamped attorney drafted charges pilot program, which was initially launched in 2019 prior to the pandemic and was revived in FY24 upon the request from several CBO groups with which OHR regularly engages. The pilot program was in place from July through December of 2024 and has received welcome support from CBOs who have already taken advantage of OHR's updated charge drafting guidance. The pilot has been extended to March 2025 so that OHR can receive and review community feedback before implementing the program permanently. In FY24, the District of Columbia took significant strides in empowering incarcerated residents through the passage of the Elections Modernization Amendment Act. This legislation enhances the DC Board of Elections' ability to track and update voter registration information for incarcerated individuals, ensuring their rights remain intact through transitions between the Department of Corrections and the Federal Bureau of Prisons custody. In partnership with the League of Women Voters, OHR developed an online voting information session, which was shared with 7 Federal Bureau of Prisons institutions housing DC residents. This resource is a crucial tool for educating voters on their rights and the registration process. OHR remains steadfast in advancing civil rights and equity in the district. By focusing on operational excellence, community engagement, and enforcement, OHR has laid a strong foundation for addressing emerging challenges. I want to extend gratitude for the ongoing support of the mayor, the council, the Committee on Public Works and Operations, my colleagues at OHR, and our community partners whose collaboration is essential to this agency's success. Together, these efforts ensure that the district continues to lead the nation in protecting and promoting human rights. Before ending my testimony, I would like to take a moment to recognize the late Chief Administrative Law Judge Erica Pearson, whose leadership and dedication left a lasting impact on our work. Her commitment to justice and civil rights continue to inspire us, and we honor her legacy as we move forward. Thank you for the opportunity to testify today. I welcome any questions you may have.
Thank you very much. If it's okay, we'd like to hear the testimony of Chair Zawa next, and then we'll go to questions. Thank you.
Good afternoon, Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations, and members of the public. My name is Motoko Aizawa, Chair of the District of Columbia's Commission on Human Rights. Thank you for this opportunity to discuss the activities and accomplishments of the Commission in fiscal year 2024 and fiscal year 2025 to date. The Commission on Human Rights has 2 functions. First, to serve as a body to adjudicate complaints brought under the DC Human Rights Act, and second, to help promote awareness of the human rights protection that the Human Rights Act affords. You are already very familiar with these functions, so I will describe them only briefly. The Commission is a quasi-independent administrative body that is affiliated with the Office of Human Rights or the OHR. The Commission consists of up to 15 commissioners who are appointed by the mayor and confirmed by the DC Council, and administrative law judges, or ALJs, who are engaged by the OHR and adjudicate cases that are certified from the OHR for public evidentiary hearings. Currently, there are 6 commissioners and 2 ALJs. The Commission, together with the OHR, provides administrative relief for violations of civil rights laws that occur in the district. This begins with a complaint filed with the OHR, which is mediated, investigated, and, if applicable, conciliated by the OHR. There are 2 types of cases. 1, public sector cases filed against the DC government, and 2, private sector cases filed against non-government entities. The former cases are adjudicated by the ALJs, whereas the private sector cases, if the OHR finds probable cause for discrimination following investigation and conciliation has failed, are certified for a public hearing before the Commission. The main responsibility for the adjudication process falls on the hearing unit, currently staffed with a short-term extern, a legal assistant, and 2 ALJs. Acting Chief ALJ Brandis Ash directs the day-to-day activities of the Commission and, among other things, is responsible for tracking and managing all the cases OHR certifies for evidentiary hearings, including discrimination claims filed against district government agencies that are finalized by the OHR's director, with the support of the agency's Office of General Counsel instead of the Commission. The hearing unit welcomed a contractor ALJ, Judge Henry Floyd Jr., in the summer of 2024. Before proceeding to a full evidentiary hearing, the ALJs issue a scheduling order under which the parties exchange discovery, following which they file motions for summary judgment. The presiding ALJ then concludes a full evidentiary hearing, as in trial, except for a few distinctions in formality and parties' burden of proof, for example, and parties are afforded opportunities to present evidence and witnesses. After the full hearing is completed, the ALJ assigned to the case will request a tribunal of 3 commissioners to review the case, and a final order is prepared by the ALJ. The tribunal then meets to discuss the case and either adopts, amends, or rejects the proposed order. Once a decision is finalized, it is issued to the parties. The Commission meets bi-monthly to be briefed on developments, including status reports on cases pending with the Commission, updates from the OHR, and various committees and any other activities. We periodically receive training to stay updated on changes in relevant DC laws and regulations and other developments. In addition to this adjudication role, the Commission has another important role, which is one of education and outreach to help raise awareness of the benefits of the DC Human Rights Act. I will now turn to our key achievements from FY 2024 and 2025 to date. I will preface this by sharing with you that we had a couple of setbacks that affected our ability to perform anything other than our most basic functions. First, our Chief Administrative Law Judge, Erica L. Pearson, sadly passed away in July 2024 after a long illness. After she went on disability leave in the spring of 2024, the hearing unit was left with ALJ Ash to adjudicate all public and private sector complaints under the Human Rights Act and, among other things, provide admin support for the Commission, at one point with no help from interns or legal assistants due to gaps in appointments. To address the severe staff shortage, a contract ALJ, Judge Floyd, was brought in to help reduce the workload. The 2 ALJs have worked diligently with the commissioners to maintain operations and adjudicate cases. To add to this challenge, The commission for some time has been operating with only 6 commissioners. The current 9 vacancies resulted from 2 non-renewals in December 2024, 4 resignations, of which 2 occurred in FY24 and 2 in FY25, and 1 resignation in FY25 due to 1 commissioner's move to the hearing unit as a contractor ALJ. And our vacancies persist due to delays in getting the 4 new commissioners already identified last spring confirmed and sworn in, even though we have been working with the Mayor's Office of Talent and Appointments diligently to ensure that they join the commission as quickly as possible. We are now in the process of identifying additional candidates so that we reach a full roster of 15 commissioners within the current fiscal year. Given the state of the commission, the existing 6 commissioners are having to rotate to the tribunal rotation schedule faster. And if somebody is unavailable due to business travel or other reasons, our turn on the next tribunal comes even faster. Sometimes the chair of the commission steps in to fill the tribunal position. Considering these constraints, I am proud to report that the commission managed to help resolve 9 cases in FY24 and 4 additional cases in FY25 to date. One of the 4 cases in FY25 included the issuing of a final order in a long-lasting complaint filed back in 2012. In addition, ALJs resolved 1 public sector case in FY24 and another in FY25 to date. As promised in FY24, each commissioner entered into a commissioner agreement that outlines the expectations for commissioner conduct when participating in tribunals. The agreement codifies our current practice. And going forward, each new commissioner will be asked to sign this agreement as part of their onboarding process to ensure that they are committed to the key protocols and time commitments required for the smooth operation of the tribunals. We are happy to report that a dedicated legal assistant in the hearing unit is now taking the initiative to compile an archive of older cases. While we had to give up hope that papers sent to archives can ever be retrieved, we are trying to piece together available cases and to digitize and post them publicly so that they serve as an inspiration for all who wish to pursue human rights protection in the district, and also serve as a basis of long-term trend analysis and other reviews. In addition, thanks to a joint effort by the Commission and the OHR, more historic and comprehensive information on the Commission is now available on the Commission's website. These efforts help raise awareness of the protection afforded by the Human Rights Act and the workings of the Commission. Turning to our activities in FY24, our awards committee organized yet another successful annual Human Rights Awards ceremony. The 2023 ceremony held on December 7th focused on disability, since disability is the 3rd most common basis for discrimination complaints following race and gender. Our event was organized under the banner of protecting and celebrating bodies and minds of all abilities, and the Commission enjoyed partnering with 3 relevant DC agencies: the Office of Disability Rights, the Mayor's Office of Deaf-Blind and Hard of Hearing, and the Department of Behavioral Health, in addition to close collaboration with the OHR. The Commission's main human rights award, the Cornelius Neal Alexander Humanitarian Award, was awarded to Tony Brunswick of Art Enables, the district's only art gallery and studio solely dedicated to amplifying the careers of artists with disabilities. Approximately 100 participants attended the event. The Rules Committee's activities were suspended in FY23 due to OHR's limited resources and remained mostly dormant in FY24, as did the Outreach Committee, which lacked volunteers. Moving to our priorities for FY25, The Commission will continue to focus on adjudication as well as education and outreach to community. Our priority continues to be moving cases to closure. We look forward to welcoming the 4 new commissioners upon confirmation and to filling the remaining 5 vacancies as soon as possible so that the Commission can fully be responsive to caseload demands as well as to the sound operation of the 3 committees. In addition, the ALJs hope to continue to offer mediation to help complainants, especially the pro se complainants, resolve cases faster. Regarding the digitization of past cases, as mentioned already, the Commission hopes to make progress in FY25 and looks forward to reporting more fully on our efforts. The Commission, through the Rules Committee, will endeavor again to take up the revision of the procedural rules in Chapter 4 of the DC Municipal Rules in collaboration with the OHR. Areas of priority will include changes to reflect the requirements of the Fairness and Human Rights Administration Act, which was signed into law in January 2025, as well as areas that need updates and clarifications based on our own adjudication experiences. Given the size of the Commission right now, we do not expect this committee to be fully staffed and operational until later in FY25 or 26. With respect to our educational and outreach efforts, the Commission hopes the new commissioners will bring new vision and vigor to the activities of the Outreach Committee, which will include organizing the Commission's annual Human Rights Awards ceremony in collaboration with the Awards Committee and additional new activities to be identified. Many of the past and planned Commission activities that I just described are only possible through the excellence, dedication, and persistence of the ALJs, for which the Commissioners are deeply thankful. The circumstances around the ALJ's job satisfaction have not improved significantly despite discussions with the OHR. While temporary measures were put into place, these are short-term Band-Aid measures, such as hiring a contract ALJ and legal assistant with uncertain terms. At this time, we do not know whether or how the contractor ALJ position might be turned into a permanent one. As such, we will continue to have concerns over our challenges, such as 1, ensuring continuity and consistency in our adjudication and resolution of complaints while facing the potential expiration of the short-term measures. 2, the ramification of operating without a third ALJ who should help relieve the pressures on existing ALJs. And 3, other important conditions that affect the ALJ's morale, such as lower salaries and substandard physical office environment. These challenges have been amply documented in this Commission's statements filed in conjunction with annual performance oversight hearings over the last few years. We believe that durable solutions should be available to counter the setbacks of the recent past and present, despite budgetary and other challenges that the OHR and every other DC agency face at this time. This committee needs no reminder that the Human Rights Commission is a distinct organ among others that contribute to the improvement of lives of those who call the district a home and those who visit this magnificent capital to work or play. We are a very small but unique embodiment of the district home rule, a valiant initiative to endow the district residents with power and a platform to determine their own fate. We sincerely hope that additional resources are made available in the very near future to address our challenges in the hearing unit and the Commission, so that we in turn can offer our resources and hope to residents, workers, and visitors afflicted by discrimination. In closing, we appreciate this opportunity to share our challenges, accomplishments, and thoughts for the future, and look forward to your advice and guidance. Thank you for your attention, and I am available to answer any questions you may have.
Thank you so much. In fact, I'll begin with you, Madam Chair. What do you think has led to the commissioner shortage and the resignations that occurred last year?
Yes, that is one of the key questions that we also grapple with. In terms of resignations that we had, they are basic attrition that we have experienced year in and year out. So I would not attribute anything specific to those resignations. But we did have this extraordinary situation where in addition to the resignations, two commission members decided not to renew their appointments for, I guess, how shall we say, a match with commission's demands. So that was unexpected, and we lost one commission member to the hearing unit, which actually is a nice promotion for the commissioner. And then I think the key problem that we had was the 4 commissioners that had been, well, would-be commissioners already identified last spring had not joined us due to the fact that they have not been confirmed. So those 4 vacancies need to be filled, i.e. the confirmation hearing needs to be organized for those 4. We have started to interview for the remaining 5 vacancies. And we just hope that the process of filling those vacancies can be expedited so that within this fiscal year, we can fill all 15, the commission will have all 15 positions.
So just some dialogue over here. We got 2 nominations last year that I thought we had moved out of committee. Let's go through the names of the ones you're waiting on so we can make sure we're talking about the same 4. If you would.
So apologies, I do not have those names in front of me.
That's fine.
But there are 4 that Mota is very well aware of.
Oh, so they haven't been sent to us yet?
No,
Oh,
I do not believe that they have.
okay. Okay. Yeah, here, okay. So is Commissioner Anderson still on the commission? Oh, I see that. So we still have you, Commissioner Baldwin, Commissioner Burnett. Tamil, okay. Okay. Commissioner Baldwin. Okay, got it. And Mayor, right? Adam Mayor?
Yes.
Very good. That's what we did, yes, we moved him. Okay. So the follow-up, the pain point then is the Mayor's Office of Talent and Appointments. You had me worried that it was us. I'm glad it's not, but if it was, we could solve it more easily, unfortunately. Okay. So we can do some follow-up on there. But it sounds like private sector cases continue to be heard even with the commissioner shortage.
Yes, we rotate rather quickly.
Yes.
The rotation.
Yes. And I do recall when you were instituting this, you set out to institute this new policy with commissioner agreements so that you had an easier time convening the tribunals. Yes, so thank you for doing that. But it sounds like that did deter a couple commissioners from remaining on. Yeah,
Yes.
Okay. And in the past, it was voluntary who joined a tribunal. Was that right? The case would come up and people could say, yes, I will join.
That's correct.
Okay.
But now the rotation is mandatory.
Yes, makes sense. Given the current staffing constraints, including the loss of the chief ALJ and vacant commissioner positions, how how do you plan to continue your operations in the meantime? I mean, it sounds like just a lot of extra work for everybody.
Yes. So we have been managing with the acting chief ALJ
Okay.
and the contract ALJ, whose contract, I believe, was 1 year. So we need to figure out how to continue this arrangement or have some other arrangement. And I would like to continue to explore if there is any chance of relieving the existing judge's workload, whether it's the third ALJ position or anything else that might be available.
A similar contractual arrangement?
Or anything, at this point, we could consider anything from more permanent legal assistant positions to other support mechanisms to ease the judge's administrative burdens. So this is me saying I have not consulted with OHR or the judges on exactly what our asks are, but I think that we have to be very practical to keep the cases moving.
Great. Has it impacted the timeline for case resolution?
I think I have to be honest to say yes.
Are you worried about or anticipating any further staffing shortages?
Not that I know of. You mean the hearing unit?
Mm-hmm.
Yes. So I am not aware of the shortage challenges, but I cannot predict the future.
Mm-hmm. Fair enough. You testified that durable solutions should be available to solve the commission's challenges. Is there anything the committee or the council in the whole can do to address these challenges?
So I think that we are, well, as I mentioned in my testimony, I believe all district agencies have budgetary challenges. OHR is no exception. But over the years, I am just afraid that the arrangements that we have became more and more temporary, right? And so contractor positions are a way to fill vacancies or a way to fill urgent needs. But the office could consider staff positions so that there is more continuity with the ALJs as opposed to all of us being in an uncertain position of whether we are going to lack an ALJ support at any given time.
That's helpful. Thank you very much. What are the key, are there any challenges to recruitment for commissioner positions?
No, I don't think so. We do have enough interest from outside applicants. This is my impression from MOTA. And we tend to have very enthusiastic applicants when we interview them. So I don't think that it's because of lack of public interest in the positions that we are in this current situation.
Okay.
In fact, I am told that the four would-be commissioners are highly enthusiastic. So that gives us a lot of hope that there will be new energy in the commission.
Yeah, it's going to need some. You guys are very tired. Okay, well, I am committed to following up with MOTA formally to request that those appointments be sent to council immediately. Thank you. How does the commission plan to, I just feel bad asking these questions, but okay. How does the commission plan to mitigate the risks of overburdening the remaining commissioners, given the high turnover, et cetera?
So I have been quite honest in my statement. The committee activities are not very active at the moment. So the Rules Committee is not operating, the Outreach Committee is not operating. And I think that For example, the Rule Committee not having been fully constituted and active meant that we unfortunately did not act on some of the opportunities to amend the DC municipal rules or other rules. For example, the commission, the tribunals are required to be formed even in dismissals following settlement of cases. I think that there are far more easier ways to dispose of certain cases that would not require all of us to physically meet, for example. So those rule changes could have been in place had the committee been in operation and had OHR also had the resources to focus on those rule changes. But we simply could not, and I'm not faulting anybody at this point. We just simply did not have the resources to do this. So we curtailed the committee activities. We are also operating without officers other than me. So I have pretty much cut down everything that I can cut down, and I step in wherever I can step in. That is the current situation. I am trying to be very mindful of the fact that all the commissioners are volunteers. They meet at unusual times during lunch hour, after hours, in order to meet to adjudicate cases. And so I just want to give them as much room as possible to do what they need to do. And as a result, other extracurricular activities, so to speak, are currently under suspension. We do need to advertise that we are going to have the Human Rights Awards ceremony, we hope, March the 4th in collaboration with Georgetown Law Center.
Very good.
So watch this space, please.
Yes, absolutely. How is the commission monitoring the impact of the new provision in the Fairness and Human Rights Act, allowing complainants to opt for DC courts up to 30 days after discovery? And how are you monitoring the workload of the hearing unit?
So my understanding is that OHR is currently trying to assess the budgetary impact of implementing all the provisions under the Fairness Act, including the new change that would enable complainants to file de novo cases even after discovery. So we await for OHR's analysis on this particular point. We do anticipate that the provisions may impact certain complainants, perhaps pro se complainants, differently from those who are represented. And I think that there are potentially opportunities to provide ample guidance upfront for pro se complainants, so that they are aware of various timelines and opportunities that they have that are built in now within our procedure. So we are still in an assessing mode, I would say, and we will take the guidance from OHR in terms of budgetary implications.
Thank you. What strategies are being developed to ensure that limited hearing unit resources are not diverted excessively to cases that eventually move to DC courts?
Currently, none. I don't think we can say that there is a strategy other than, as I mentioned, more opportunities for fair warning up front, right? For litigants to be able to, complainants to be able to know what their options are and to hope that those options are exercised wisely. I think that is the only thing we can do at this point.
Mm-hmm. Regarding the ALJ shortage, how many ALJs does the commission need for a sustainable staffing model?
So at one point, I have been on the commission since 2012. We have had one period in which we had 3 ALJs. So it is true that we did not always have 3 ALJs continuously for all this time. My impression is that when we had 3 ALJs, the burden on the other ALJs lessened significantly.
Mm-hmm.
So we need to consider how to ease the burden of the existing ALJs And as I mentioned, that might be a third ALJ, that might be a combination of other measures that would help ALJs do their job better, faster, such as other supporting mechanisms.
Do you have an idea of an ideal mix of ALJs and legal assistants for the commission to be most efficient?
I don't. What we have right now is an extern who is extremely short-term, was there only for 10 weeks, coming from a law school. So just discounting that, the legal assistant position, as I understand it, again, is a short-term position. I would love to see something that is more enduring, so that the continuity of the knowledge of the office is not lost so often. We do that annually. So we have a proper staff position as opposed to having to rely on law school to provide stipends and supplements for these positions. We would love to have appropriate legal assistant positions that are enduring so that they can also carry the knowledge from one year to another.
Your current arrangement, if I recall correctly, with legal assistant is a 1-year term from a law school, is that right?
I believe that is the case, and Acting Chief Judge Brandis Ash, if I get
Is
that
on
wrong,
the Zoom right now
yes,
too.
please
Yes.
let me know.
Yes. But but a legal assistant, the category of that position could be a long-term position. It's just the current arrangement, which is more affordable, is through the law schools.
It's more
Yeah.
affordable.
Yeah.
We have no objection working with law schools. It's just that these people come and go.
Sure, absolutely.
And we also need to recruit for them. And if recruitment doesn't occur in time, we will not have a legal assistant, which is what happened last year.
Right, I recall. Okay. And Chief Judge Ash is in the Zoom as a panel. If the judge wishes to respond to this, you're more than welcome to do so, but no pressure.
Yes. Yes, I do. Thank you, Council Member Nadal. So specifically as to what we need and what would be helpful, I'll just, without rehashing Chair Zawa's very succinct testimony, I will say we need 3 ALJs. The chief ALJ, as is the case with most chief judges, is responsible for, as Chair Zawa mentioned, a lot of administrative duties. And so what's been happening with only 2 ALJs is there's often sort of a toss-up between, putting administrative duties to the side for a little bit, or I'll do this over the weekend, or, whatever it takes to get it done. But basically carrying the same workload, if not more, than the second ALJ. So in this case, you can imagine when, Chief Judge Pearson, my friend and colleague, passed away, I was left with all of the cases and administrative duties. And to speak to the current intern situation, we have an extern from a school for 10 weeks, and we have a legal assistant who is working with us for, as I understand it, into the foreseeable future. The ALJ is working with me, thankfully, on a contract basis as of now. But again, it would be helpful to have a third ALJ to just equalize more of the workload. And I do want to speak, because I want to give credit where credit is due. With all of the things that have occurred over the last several months, and certainly this kind of, is a segue back to the testimony of Mr. Patton a little while ago. At this time, or as of Q1 at least, we only have 5 out of 21 cases that are considered aging. So we have worked extremely hard, weekends, 3 a.m., whatever it takes, to still keep our caseload at, I would say, at a level where we're doing things as efficiently as possible and moving things along. And out of those 5 cases, these are cases, some that I inherited from Chief Judge Pearson, but that have been on our docket for a very long time. And I also want to give us credit for getting rid of or disposing of a case that has been on our docket for several years, the longest case that we've had. That is now in an appellate posture, but that is a 6th case that was on our case as aging, but it's now been dissolved or disposed of. So, I just want to be very clear for the record. What would be helpful is to have 3 ALJs. And as to our fellowship position that our agency has actively taken part in over the years with Georgetown, in that case, I'm not sure what's going to happen in the future, but as it relates to the fellow that came on board, that does kind of come down to timing. Usually around March is when the law school and the chief ALJ work together to onboard possibly someone in the fall for a 1-year fellowship. So, it is essentially a clerkship, a judicial clerkship, but yes.
Very helpful. Thank you. Well, thank you both for your testimony. Those are all of the questions that I have for the commission, and I appreciate you joining us. And we'll now hear directly from Director Saunders and the OHR team. Thank you for your patience. Congratulations on the 10 new hires. I'm very happy to see the agency is making progress on recruitment. You testified, Director, that in FY24 and continuing in FY25, OHR established a comprehensive 8-week training for current and new investigators. Does this include training for intake officers?
Yeah, it's comprehensive training. We're also going to have a dedicated intake training. But that is something that when I came on board and I pulled most of the investigators, it was a need for a structured training. We wanted to do that live so that when we hired individuals, which we did last summer, we tried to wait until we had a large enough pool because I think there is value in a classroom setting. A lot of times if training is remote, people don't really have to pay attention.
Yeah.
So I think that it was, in talking to staff and even the managers, I think that they appreciated that. And all of that was set up to have a more regimented approach in looking towards having that intake unit and putting more measures into our performance.
So the dedicated intake training is a future thing?
The intake officers will be doing that. That's, once again, speaking with the AD, that is something that all of the intake officers will do. We've had that training. That'll probably be over a week and a half, but bringing them together in a classroom setting when at all possible, so that when we stand up that unit, essentially giving them the tools to be able to identify, what those issues are, the drafting, and meeting with the AD is of having debrief sessions on what an intake should look like. A lot of times when we talk about backlog, a lot of the factors that we're looking at doesn't have to do with the personnel. It has to do with the quality of the intake that's coming in.
Right.
And things of that nature. So working with the new AD, this is something that I thought about doing when I first came on board. I think overwhelming within the enforcement unit, from the investigators to the managers, they were for this. But we onboarded the AD because it is a heavy lift. So that's what we're planning on doing moving forward.
And when will that take place?
I think we're probably looking, as of right now, we're in the search for the intake supervisor. So once we secure that position, and I think right now we're probably looking at hopefully March. We were going to roll that out earlier, but we had to postpone it.
Okay. Any ongoing barriers generally that could be addressed by this committee or the council as a whole?
Not off the top of my head, but I'd like to, hold on 1 second. Not at this time, but I'll get back in touch with you.
Okay.
When we can prepare a document.
How many FTEs are there right now at OHR?
Right now, I believe there are 70, I think it's 71. 9 are frozen. And I believe as of right now, we have 7 vacancies, 5 of which are in enforcement. So it's 73. We have a vacancy rate right now, I think it's 8.5%.
Why are they frozen, the 9?
I would have to talk to my administrative officer and I can get back in touch with you. Maybe for budget savings.
She's on the Zoom, right?
Okay.
Okay.
Good afternoon, Chairperson. So we have a total, how are you? We have a total of 81.5 FTEs for the agency. 73 are local, 2.5 are federal, and then 6 are UPL funded by DOES. In terms of the frozen positions, those are frozen to meet the mark.
I hate that. Okay. And do you have a forecast of when any of them might be unfrozen?
No, not at this time.
How many are vacant in intake?
So of the 7 vacancies that we have, 5 are in enforcement, and I believe 2 are in intake.
How about investigations?
It would be 3 in investigation.
How about alternative dispute resolution?
We have 1 person onboarding. They should be onboarding at the end of this month, I believe on February 24th.
Thank you.
Mhm.
Are any federal government grant funding sources frozen right now?
Or FTEs.
In general?
In terms of for personnel services, no, we have 2.5 federally funded FTEs, 1 from EEOC and 1.5 from HUD. In terms of any non-personnel grant funding that's on hold, I don't believe so, but I can defer to our AFO for that response.
Good afternoon. I'm not aware of any impacts, but we can certainly get back with a confirm that.
Thank you. The agency responses indicate there was a budget reprogramming in FY24 for contractual services within the investigation section. The approved budget for local funds was $369,000, but $40,000 remained unspent. Can someone explain that one for me, please?
I have the FY24 enhancement. Ayana, is that something that you can respond to?
Could you repeat the question, council member, and also the corresponding question in the responses that we submitted?
Yeah, do you know the corresponding question for that? Oh, okay. This is in reference to the council approved budget sheet that was submitted with the responses. So the
Okay.
question is, the agency responses indicate there was a budget reprogramming in FY24 for contractual services within the investigations section. The approved budget for local funds was $369,000, but $40,000 remained unspent. Yeah, can you explain the underspending?
Sure. So the reprogrammings that we sent in our documents, just to pick normal shifts in funding due to the agency meeting operational needs and performance goals.
I see the agency also reprogrammed $269,000 from investigations to contractual services, and the reason stated was to reduce the backlog. Can you explain how that reduced the backlog?
Director, would you like me to speak to that, or would you like to speak to that?
You can speak to that.
Sure. So some of that money was reprogrammed so that we could hire contractors to assist in that regard. And that was contractors for the enforcement unit and also funds to support the contract ALJ in the hearing unit.
And where did those funds come from?
I would have to defer to our AFO to confirm that. I believe that they were a reprogramming from PS to MPS.
Sure, I can look into that and provide a detailed response. I'd have to look at the full picture.
And did that reprogramming lead to the freeze of those 13 positions?
No, the freeze was attributed to the mark, meeting the mark.
Okay, understood. All right, Director, can you provide an update on the implementation of the new case management system?
I think we're in the process of finalizing that in the implementation stage. So when I came on board, we were going through the vetting and the TEP process. So that's wrapped up. So I think we're just finalizing the contract. I've been working with staff on designating that team for that implementation. So I think that that should start pretty soon.
Like this month?
Excuse me?
Like this month, this quarter? Well, I guess this month.
I would imagine that it would probably be this quarter.
Okay. All right, let's discuss the agency's statutory mandates. Open Movie Captioning Requirement Act of 2024. When do you plan to do the first audit?
We completed the first audit. We got the results back last Friday. There were no violations.
Great. Love to hear it. Have you received any complaints?
I believe that we did receive some complaints. One complaint.
One complaint. Any more specifics you can share on that?
No, not at this time.
Okay. And that is because it's in progress?
I think they are evaluating that. The way that complaint came in, it didn't come in through the audit. So I think that someone is taking a look at that. If we find that there's a possible violation, we'll shift that over to the enforcement unit, but I'll let the general counsel speak.
Good afternoon. I believe we received several communications through the open movie captioning email, and there was one complaint where a violation was suggested. So my understanding is that the team that works on that is reviewing to determine whether additional showings need to be implemented.
Okay. Are you able to share which theater it was?
I'm not aware of that at this time. I can find out.
Thank you. How's the agency notifying consumers of the new requirements for theaters?
Thank you, Chairperson. We developed a guideline to share with NATO, which is I believe is the National Association of Theater Owners. And we've been discussing with them how to share with other theaters that we might have missed.
So it's something that you expect is posted at theaters, or how do consumers know about it?
Oh, for promotion of the, also we've dedicated a webpage for the Open Captioning Requirement Act, as well as a social media campaign. And we're currently in works with the Mayor's Office of Deaf and Blind and Hard of Hearing to host an event that really promotes the act, but we're still in the logistical phases of it.
Great, thank you. Turning to the Domestic Workers Employment Rights Amendment Act of 2022, what challenges, if any, has OHR encountered in enforcing the new provisions?
James, you want to speak to the outreach part?
I think we've heard from our witness earlier from the Domestic Workers Alliance is outreach. Mainly, we have a hard time reaching the core demographics that are affected by the act, and we're actively working with the Domestic Workers Alliance to curate an educational pamphlet that could be useful. And once we have that, as well as translated, we'll be sharing it with relevant offices, especially the Mayor's Office of Latino Affairs.
Great. And there were some specific concerns about language access regarding this law. I assume you all heard that testimony about that on the website. Can anyone speak to that challenge and what you're going to do to resolve it?
We're grateful for our partners to raise that. We'll be actively reaching out to the FTC and working alongside with our language access program to make the necessary translations. And I believe they said some language regarding the guidance that we have. We'll be seeking out their advice on how to make sure that the pamphlet that we are creating resonates with the population.
Is there any way that that you can you specifically respond to the concerns about the existing website and the translations there?
I believe that, I know Rosa's not here today, but
Right.
she was watching, and I believe she is looking into that in terms of what the link issue is.
Okay.
Because it sounds like maybe what they were saying is that the links are not directing to the right translation.
Okay. Thank you. For the external guidance and employer notices that the agency has issued, has there been any feedback or requests for clarification from stakeholders?
None that I have received. And I think I would just like to add, when we're talking about this act, is I think one of the participants earlier today spoke about something not being in plain language.
Sure.
And we probably need to, I know that that was an effort long time ago. So I can imagine if you're getting something and it's citing federal laws, James and I had a discussion about that, is maybe reviewing the documents that they are being sent to and making sure that those are in plain language and they're not confusing.
Great. That would be very helpful. And what specific updates or changes does OHR plan to make to the Language Access Act regulations?
What I can speak to, I'm not aware of the specific changes, but we have proposed, I believe, temporary and emergency amendments that we had discussed with council to allow us to amend the regulations. We had received guidance from OAG as to the authority necessary to pass regulations. So.
Okay, so is that something you're moving forward with then?
Yes, I believe our office has been in discussion with your office about the proposed amendments.
Great. So we've heard from the public that, let's see, we talked about that. Hold on a second, just now. All right, so with respect to the District of Columbia Language Access Act of 2004, in the FY 22-23 OHR annual report, under language access charges, there were only 3 docketed charges in FY 22 and 1 docketed charge for FY 23, which seems very low. Why is that?
I think I would need to talk with the intake staff and the investigative staff, because that number does seem to be extremely low.
Okay, but do you have another number that you think it is?
No, I think there's a difference between the pre-complaint stage, where a lot of those matters get resolved before they are docketed as a charge for investigation of a violation. So Rosa and her team do a lot of the pre-investigative work before a charge is docketed.
Is that tracked anywhere? How many of those cases are resolved before a charge is documented?
I don't have that information, but I can certainly get that back to you.
It exists.
I'm not sure if it's tracked in terms of the pre-complaint. Is that what you mean? How many pre-complaint?
Yeah.
I can find that out.
How many docketed charges were there for FY 24?
I would not know. I would have to get back in touch with you.
I mean, for language access.
Mhm.
Oh.
How does OHR assist DC agencies in improving language access for residents with limited English proficiency and ensuring compliance with the DC Language Access Act?
I know first and foremost, we have the training. Rosa isn't here today. I know she does a lot of that work.
Do you mind repeating that question again?
How does OHR assist DC agencies in improving language access for residents with limited English proficiency and ensuring compliance with the DC Language Access Act?
I believe the language access program, they provide trainings for the language access coordinator for each district agency, as well as they're currently reaching out to the ANCs to promote a resource that allows interpretation and language access act or language access service to those who need it.
What actions does OHR take when an agency fails to comply with language access requirements, either through field testing or individual complaints?
The language access program works with the affected district agency's language access coordinator to amend those and make sure that they're in compliance.
What actions has OHR taken against non-compliant agencies?
They issue a non-compliance order.
Okay, moving on to case backlog and investigation delays. Excuse me. We had witnesses testify that from their observations, there seemed to be a dispute between the enforcement division and the hearing unit on whether cases can be disposed based on the law or litigation motions. Well, what's going on here? Can you shed some light on that?
Yeah.
I believe you were talking about Mr. Patton's testimony. I think without getting into too much details about that matter, that is a matter where OGC is working with Mr. Patton and his client in the litigation of the probable cause finding at the commission. And there are summary judgment motions pending before the tribunal. A summary judgment motion was granted and is now pending a review by a tribunal.
Yes. And if I could speak to that a little bit more, I know Mr. Patton started out discussing dates as far back as 2020, but specifically, that case was not certified for a hearing until 2021, and there were significant challenges that presumably Mr. Patton is aware of those challenges, even though he did not come into the case until late 2022 or 2023. And so to Interim General Counsel's Nias's point, there is only a tribunal to be scheduled. Specifically, the last 6 or 7 months or so is probably what he meaning Mr. Patton could speak to as it relates to any potential delay. But a tribunal was scheduled. It's just a few issues that need to be addressed. The parties in particular requested a number of extensions, I'll say, to file exceptions to each other's filings. And so at and around that time is when we suffered even more of a short staffing with Chief Judge Pearson passing and me being the only person in the hearing unit. But a tribunal will be scheduled soon.
Thank you very much, Judge. What is the current backlog of cases?
With the commission or?
Oh, I'm sorry, for this one's for the director.
Okay.
Thank you for checking.
No problem.
I'm sorry. Last time we checked, there was approximately 775 cases. There were over 180 days backlog, yes.
Thank you for that. And on average, how many complaints is an investigator assigned at one time?
Those will rotate as they go out of the intake unit. I think right now, most of the investigators are carrying something between 26 to maybe 28 cases,
Okay.
but those go out on a rotating basis.
Witnesses have testified about delays in the complaint process. Can you provide the average duration for each stage, including intake, mediation, and investigation?
I think there was some discussion earlier, and the Associate Director for Enforcement, I think she looked at some numbers, and we're looking at probably from individuals contacting us to being scheduled for an intake, anywhere between 3 to 4 months. So one of the things that we've done in working with the associate directors when we stand up the intake unit is that those individuals will be assigned a certain amount of intakes, per day, 3 days a week, 2 to 3 intakes. I think conservatively, the way we looked at that, that would increase our capacity by at least 50% to handle those intakes. So when somebody contacts us to the time they get an intake, the second issue, of course, is the mediation. We've had some struggles in standing up that unit. We do have a new hire that's coming on board. So right now in the ADR unit, you have the manager of that unit is primarily working with contractors and scheduling those. So on onboarding that staff and having those contractors, hopefully we'll be able to move those through the intake unit, through the mediation unit, and then on to the investigative units.
So what is the average for the mediation?
That number I don't have, and I can try to get that back and get back in touch with you and have the manager provide that information.
And what about the investigation average?
I don't know. All we have is that backlog. So, but I will say that moving forward, one of the things that we're doing is we're coming up with a target of investigations per month, per investigator, a minimum of 2. So that will help with their caseloads of getting those through. But if you're looking at it, we have cases from 22, 23, 24, and 25. So that gives you some idea of what that backlog would be.
Okay, that's helpful. Thank you. Are certain types of complaints processed more quickly than others?
Yeah, that's one of the things that we're really looking at. I've talked to the AD and I've talked to some of the investigative staff because I hear it in discussions and some people's testimony of triaging and prioritizing certain complaints when they come through. I think there's a benefit, and sometimes some complaints are cases of first impression, and they shouldn't just be lined up in the queue. I think a lot of times if you're talking about, if you're having maybe some director's inquiries, but some cases just on their face don't really take that much investigation. And with having that intake manager who can identify those we can move up. Some cases are going to take a while. Some cases have 10, 15 allegations. Some maybe have 1 or 2. So what we need to do is review those and dispose of those properly. And those can move up. Of course, the investigators will like that because it's a closure for the month. It really doesn't take that much work. A lot of times the information is right in the complaint. You can make a request for information and things of that nature, and those cases can be resolved fairly quickly.
Did you say when the intake manager is going to be hired?
We're in that process right now.
That's being finalized, or just recruiting, or what?
I think it's probably a combination of both. And I think my general counsel just pointed out also, the fact-finding conferences also help with that. That is something, when I first came on board, the state of Maryland has a fact-finding process where they take all of their cases through fact-finding. I don't know if I would like to do that but that is a good opportunity for people to identify those type of matters. It's sort of like a mini hearing, so that everybody knows what position they're in. And coming out of a fact-finding conference, I think for the most part, the parties know where they stand, and those can quicken resolution.
What is the oldest unresolved complaint in the OHR process?
I don't have that, but I think that we could probably get that for you.
Do you know how many complaints filed 3 to 5 years ago are still pending?
I do not, but I think we can get that number from you too. I think that we can get that to you by year.
And what's your strategy for addressing those delays in those older cases?
The strategy moving forward is for the investigators who now have a minimum number of, not dismissals and administrative dismissals and things of that nature, but written LODs. 50% of their 22 cases, 50% of their 23 cases, and 50% of their 24 cases. So with this large number of cases we have, we're trying to get to the 22s, 23s, and the 24s and reduce that by 50% this year.
When is the strategy for doing that?
The managers will manage that on their caseload, looking at the number of 22s, 23s, and 24s cases that they have.
Let me ask this. You've talked about a number of things that are sort of in the future to address backlogs and casework and workflow and all of that. When do you think we're going to see the difference?
I think we'll see it pretty soon. I think some of those, in meeting with the staff members, putting these in place, it really took to onboard the AD so that we can stand up that intake unit. So what I'm looking at, as soon as that individual comes on board, lowering the number of intakes will probably be immediate. As far as the 2 cases, I could not implement that until the beginning of the fiscal year. So that is already in place. So those are things that we're looking at. So
when do you think the people who are waiting for their cases to be resolved are going to feel that relief? Is it this fiscal year you think you're going to be getting on top of the backlog? Is it next year?
You know, I don't know. I think if you look at triaging cases and doing fact finding, some individuals may come in and say, hey, listen, I resolved my case in 5 months, but as far as seeing any discernible difference, I think that we'll see difference in the numbers. I think that is a given. But as far as individuals, I think if we do some of the things that advancing some of those simpler cases, people may be surprised that they got through that quickly. But we plan on putting this in place with the intake manager, the requirement for written LODs. I mean, we're always going to have those administrative dismissals, but the written work product, you know, that started this fiscal year. So that's already been in place.
Okay, thank you. In FY21, the agency received funding for fair housing testing. What have the results of that testing been?
We received that testing, I believe it was in December. So we are reviewing that information. I believe we had a meeting with the ERC. Right now, we are reviewing that information. I've talked to, there's some things going on over at the OAG where there may be some opportunity for us to take a look at some matters. So, in
Any
fact, I
key
think
findings that you can share?
I believe that, our associate director can correct me if I'm wrong, that the housing manager and the new associate director are still reviewing the raw testing data that we received from ERC in terms of the numbers. And so I'm not sure if we can share that yet.
Any idea when you plan to publicly release the information?
No, I don't have a date for you right now. We haven't even gone through looking at and combing through the data.
Did we receive could we receive raw data without personal identifying information at the committee?
We can check with the ERC and see if we can release the report. It was just a summary report without the raw data, but I might need to confirm with the enforcement unit.
Oh, so there
first.
is a summary report.
It's a summary report.
Okay, so any findings or conclusions from the summary report
that we can release.
that you can tell me about today?
I don't have that on me. I don't know if the associate director has more information about the specific findings. There were findings of non-compliance with certain properties, but I believe that's the data that's still being reviewed to make sure that that's accurate.
Okay.
If that makes sense.
Has OHR taken enforcement action based on past testing results?
I can only speak to since I've been here, and this is the first testing report that I have received.
Anyone else who's been here longer?
Yes, our housing, the case manager, Akita, the supervisor, or Amanda, she's very versed in this.
Anyone here today?
I don't believe so.
In FY22, the Committee on Government Operations funded a $100,000 study, industry standard study, for an independent review of case timelines. Is there an update on that study?
There was a question in the pre-hearing, I believe.
Any
about that.
update? I mean, that 2022 funding, was that concluded, and are there any updates on it?
I would defer to Ayana if she has
Okay.
information about the funding.
Did it take place?
I could provide a response to that question. It's still being drafted because unfortunately, when Director Ninkine left, she left me with the raw data, and I'm still in the process of understanding the information and making sure that it complies with OHR standards. So I apologize for the delay, but we're working on it.
Okay, so the study was conducted, but you only have raw data, so you can't yet produce a report, but it was conducted.
Yes.
Okay. What's your timeline for concluding the work?
Most likely by the end of FY25, but I will make sure it's on my priority list.
Thank you. How does OHR determine whether an issue warrants a director's inquiry versus another form of investigation or enforcement action?
For director's inquiries, I think that you can look at if there's a pattern, and that's another example of those type of cases that you may want to triage and move up to the head of the lines. If you're receiving quite a few complaints, things of that nature, I have handled those. We didn't call those director inquiries at different agencies. A lot of times it can be an ADA issue or an ADA matter. You know, whether we're talking about signage, whether we're talking about elevators, whether we're talking about slopes, or if we're talking about individuals regarding leave and those type of things. So those are the things that I look for directors' inquiries. I know we haven't had that many this year, but there have been several that we have said, hey, listen, let's take a look at this. And a lot of times it's something it's not a discrimination matter, it may be a criminal matter, it may be a licensing matter. Those are the type of things that you see. And what I have tried to get the managers to do is say, okay, is this something that may be a violation? Somebody has contacted us about it. How can we resolve this without putting somebody in line for an intake? And we've had several of those since I've been here.
Thank you.
Okay.
Can you explain what a disparate impact claim is?
I can try to handle that.
Thank you.
A disparate impact is another way of a theory of discrimination, different from disparate treatment. Typically, you see them in class actions because it involves perhaps a facially neutral policy or practice that actually has a disparate impact. It has an impact on a particular protected group. Like I said, those are typically you might see that more in a class action as opposed to an individual claim, which would be more disparate treatment.
Are there any plans for OHR to start accepting these types of claims?
I believe we have discussed that. However, that type of claim, I used to litigate federal class action complaints, and they're not uncomplicated. It involves often a team of attorneys. You need statistical analysis. You need lots of not only anecdotal testimony, but also often an expert in the field to analyze statistics about whatever the claim is. And then there are steps to take if you're talking about an actual class action, certifying that there are legal requirements. So the capacity of ROGC, for example, or the investigators to take on a disparate treatment class action is pretty limited.
Yeah.
I know EEOC does those, so we've had times where we have referred a matter to the EEOC because I believe they do have a class action processing unit and that kind of thing. But at present, it's not, I think, feasible.
When I was in Fairfax and we got those type, we were kind of directed to contact the Washington field office because there's a lot of statistical analysis. And most of those, they would go ahead and those would be dual file. We would just transfer those to the EEOC just because of the amount of work.
So yeah, very, very intensive.
Mhm.
Okay, resource intensive. Okay. Okay, that's, we'll stop there today. There's another hearing that's gonna start in this room very soon, so we will wind down. And thank you very much for your testimony today.
Thank you.
This concludes today's performance oversight hearing. If you plan on submitting written testimony for the record, please do so by going to the council hearing management system at lims.dccouncil.gov/hearings. The record will close on Thursday, February 26th at 5:30 p.m. I'd like to take a moment to remind you the Committee on Public Works and Operations will be holding more performance oversight hearings in the coming weeks. Please visit the council's hearing management system for the committee's performance oversight hearing schedule. If you'd like to testify at any of these hearings, you can sign up on the council hearing management system. The time is 1:42 p.m. and this hearing is adjourned.